Hello, court officer, is it audible? Court officer, is it audible, sir? Arun Kumar, sir, is it audible, sir?
Your Lordship, kindly, one matter civil contempt. The accused has not filed the complaints affidavit. The matter is of the year 2023. Huge arrears has to be paid and reinitiated back to service. It was ordered to be listed on next week in the February. Till now, it has not been listed.
If some date is given, then don't list.
It
Any date
is
is given?
after one list after 1 week. It has not reached.
Date is there. If not given, then after 2 weeks.
Submission, my lord.
One more matter, fresh matter. Though the office objection is complied before vacation, it is not been listed.
It will be listed.
Submission, my lord.
No, for that, no memo.
Submission, my lord.
One is also a contempt matter, wherein a compliance report was ordered to be filed, my lord, but is not filed by the BDA. This is an allotment matter.
Not by memo, it will be listed.
My lord, it was, the date was given in the month of March, my lord. I have moved 2 memos after that. It's not listed, my lord. Compliance was supposed to have been done in.
It was given or not given?
My lord, date was given in, my lord, the earlier bench had directed it to be listed in the 3rd week of March. It was not listed thereafter. My lord, I moved a memo in the month of April, my lord, but there were changes in the benches. My lord, it was not being listed because.
After 10 days.
Please.
Submission.
Interim order, I'm representing Refund. They are interfering with my possession. There is some urgency. Therefore, I have filed an application seeking interim order of injunction against some of the respect.
CIL is pending.
PI is pending since 2018.
So the IAL will be listed, not by memo. I'll and remove the office of this. It will be listed.
Contempt petition, my lord. On 18/3/2024, there is an order to comply the single judge order to the respondent, but they given 5 days time by this honorable court. And the matter is posted on 24/3/2024, 23/4, but we are not reached, my lord. After vacation, yes, the court told.
We will
Last
list
week,
it.
kindly had. Because complaint husband is suffering from cancer so far, my lord. He is undergo operation. My lord, so far, the agency.
We'll see
Kindly,
that list. No memo. We'll list it.
My lord, sir,
next week, Anna. Next week, please.
my lord, sir,
Memo is not to be.
Cancer, he is suffering from cancer, my lord.
Maybe.
Complaint husband suffering, he has to undergo operation. There is an order of the single judge to release the arrears of salary and retirement benefits. This court also directed the respondent to comply within 5 days. It is not done by the respondent, my lord. So far,
6th,
can you have it at least like next week?
6th of June.
Please, my lord, my humble submission. Because my urgency is suffering for cancer, my lord. Complaint to husband. This honorable court passed orders, my lord,
6th.
within 5 days to comply. Please kindly.
My lord, so contempt was closed, my lord, based on undertaking given by the state, saying within 2 months they'll comply with the order. They've not complied, my lord, just by 3 months, my lords.
Contempt of clause, then file application for
I
revival.
filed an application, my lord, seeking for listing of the application.
Liberty is granted.
I filed an application, my lords, for listing.
Yes.
PIL matter for preliminary hearing, my lord. This matter
Yes.
against the BBMP, my lord. They have not constructed the retaining wall at the end of the residence area, my lord. My lord, the residence area, my lord, due to the flooding, my lord, the entire area is flooding, my lord. Kindly see the photos, my lord.
So what do you want?
Photos, my lord.
What do you want?
Maybe posted tomorrow, my lord.
No.
Next week, my lord, at least one person
Only
is also
posted.
died, my lord.
No urgency.
My lord, kindly see, one person is also died due to the flooding, my lord. That's why, my lord. One person is also died in the area due to the flooding.
Listed. Next.
With your lordships kindly.
This next week, my lord. Kindly look into the photos, my lord. The entire area, my lord, flooding, my lord.
We do not.
Budget with bad smelled water.
To remove the office of this.
Yes, my lord. I removed entire office objections, it removed.
Then it will list within the 1 week. 1 week. Not by
Maybe
memo, no.
directed, my lord. There
Yes.
is some urgency, my lord, because, my lord,
We'll
rainy
take up
season, my lord.
once it is
Rainy
listed.
season, in the last week also, there is a flooding, my lord, in the area.
It is PIL.
PL, my lord.
It will be listed.
With your lordships kindly, my lord. A writ appeal, my lord, had moved it before the vacation. This honorable court was pleased to direct me to move it immediately after vacation, my lord. This threat of contempt proceedings, my lord. I've removed all the office objections. Any date convenient to your lordships.
After 10 days.
I'm grateful, my lord.
My lord, it's a fresh matter, my lord. Civil contempt, my lord. The accused was asked not to go ahead with the construction, my lord, with zero setback. However, the accused has not been complying by the Honorable High Court's order, my lord, and they're still going ahead with the construction. The construction will complete soon, my lord. Kindly post the matter at the earliest, my lord. A date may be given, my lord. Kindly keep-
After 10 days.
Much obliged.
Memo for posting, my lord. Dharwad writ petition transferred to Green Bench, my lord, after 10 hearing. This was filed in Dharwad, erroneous
13%.
14%, my lord.
Oh,
Advocate 14%.
Then, Dharwad it was filed.
Yes.
So what is to be done now?
It is transferred to Green Bench, my lord. It's a NGT case. There is a case pending in NGT also.
You go before the registrar, not before the.
Memo for, it is transferred, my lord, as per the order.
Very good. You listed, then it is transferred.
Obliged, madam.
Yes, Mr.
Serial number 37, madam.
37.
I need short accommodation, madam.
Pardon?
I need short accommodation.
It's short accommodation.
My lords, I appear for Union of India and item number 30 in list 1, my lords. I have informed the petitioner as well. I require a accommodation to be able to place my
37,
stance.
you need time.
Yes, ma'am.
Lord,
2 weeks.
AG, my lord.
My lord, in this matter, contempt has been complied with, my lords. After that, after compliance, they're seeking time in this matter, my lord.
Which one, Mr. Advocate General?
serial number 46, my lords, which my learned friend is taking.
37.
46.
Please, my lord, which my learned friend, which my learned friend is
37.
seeking an adjournment, my lords.
37. Same.
37, I'm sorry, 37.
37.
Please, my lords.
Same matter.
Same
So
matter.
what is to be done?
We have complied with the
complied.
orders
No,
passed.
he's appearing for my lord, on behalf of my lord, me, my lord.
You are with Advocate General.
Please.
So it is complied with.
My lord, I need short accommodation. We engage the senior counsel, my lord. There is some inconvenience today. Kindly after next week, my lord, we'll argue.
If my learned friends are date, your worship may kindly grant a date, my lords, no objection.
What is the direction? Let us, if it is complied with, then why you are seeking?
No, my lord. I filed an application. There is a direction by this honorable court, my lord, to determine the compensation in terms of 2013 Act, Land Acquisition Act, my lord. But they have-
So what was the direction to be complied with?
My lord,
Order 9/11/2023.
Page,
they're not single judge, my lord.
page.
Lord, order dated 9/11/2023 of
Page.
my lord, this honorable court.
Page.
Page is
The
not-
order
in
sheet.
Order sheet, my lord, order sheet. This honorable.
Which is the order they wanted to comply with?
My lord,
Lord, what has happened, my lord? The last single judge, my lord, directed the KDB to my lord pass award, my lord, in terms of new act.
Where is that Lawrence Singhali's order?
Please.
my lord, that is at page number 40, my lord.
40.
Para 22. Right, 2, my lord. Roman letter 2.
Where is the direction?
My lord. Page number 40.
40.
40 in the,
Relief number 2, my lord. Petitioner is entitled compensation for the aforesaid.
40 is something different. There is nothing.
my lord, in the petition, my lord, in the
Contempt
contempt petition. my lord.
May I pass, my lord? My
This is the first directions. my lord. This direction was confirmed by the division bench, my lord. Thereafter, it went to Supreme Court, my lord. Supreme Court also confirmed
The
this.
compliance.
lord. Washington kindly take, my lord, the order dated 9/11/23, my lord. That is, my lord, recorded, my lord, in the order dated 9/11/2023. 9/11/23.
You must have filed the compliance affidavit.
That has been
My
filed.
lord, compliance affidavit filed, that was rejected by this honorable court, my lord.
It was rejected. Thereafter, my lord, 9/11/23, my lord, this honorable court, my lord, directed, my lord, as to, my lord, calculate, my lord, taking into the date of, my lord, 2012 and 13 to, my lord, calculate the base value of, my lord, the compensation. Thereafter, we complied, my lord, the order of 9/11 and 15/12/2023.
No such affidavit was filed, my
15/12.
lord, till
Put
today.
it on record.
That is, my lord, already in record.
Put it in the record by way of further affidavit.
No, yes, my lord.
Huh?
Kindly direct them to file.
That has
further
been
affidavit.
already recorded, and, my lord, we have deposited, my lord, 12 crores, 61 lakh, my lord, before this honorable court.
Whatever it is, not orally, you put it on record by
Please,
way of
madam.
further affidavit.
Please.
Right?
And my, I
So
filed one.
You are referring to some earlier order which is not found.
Lord, 15/12, my lord, 15/12.
Not there.
15/12/2023. In the contempt, my lord, proceeding.
18/8.
15/12/2023.
After 4 weeks.
We'll file a short synopsis, my lord, so that it's easy for your lordships, my lords.
We are
There are too many
asking your,
people.
we are asking your colleague to file additional affidavit showing.
We'll
the
do that,
compliance.
my lord. We'll do that.
So after 3 weeks.
My lord, I filed one application to implead the additional accused, my lord. That may be allowed. Now the SLAO and CEO, accused number 1 and 2 are transferred to another place. So I filed another application to implead the present SLAO and CEO. my lord. Application may be allowed, my lord. I think.
Neither you are clear, nor you are clear. So we are confused.
My lord.
So let it be come after 3 weeks. You come with proper submission, yes.
My lords, in item number 30, I appear for the Respondent Union of
Item
India, my
number?
lords. 30, my lord, list 1,
Yeah.
item number 30.
Yes.
I may be given 4 weeks to file my stance before this honorable court, my lords.
4 weeks.
Please, my lords,
4 weeks. After 4 weeks.
please.
Your Honor,
Much obliged.
Your Honor,
Lordships kindly, in serial number 7, my lord, request for a short adjournment.
Your Honor, I'm party in person for serial number 7, Your Honor.
7.
7.
So what do you
7,
do?
Your Honor, party in person, Your Honor.
Lord, I request for a short adjournment in serial number 7, list 1. The council on record, my lord, is out of station. Your lordship may have it next week.
Let it
Yeah.
be called. This contempt petition only.
Yes, Your Honor, I'm party in person, Your Honor.
Yes.
Arun Kumar, a party in person appearing for this contempt, Your Honor.
Hmm.
This honorable court single bench was pleased to pass an order on 9th of August 2023, Your
Let
Honor.
it be called out, Mr. Party in person. Yes, start. Start. So 35 not to be placed before the bench where one of us indicate Honorable Mr. Justice Arvind. KV Arvind. Take it over, is a member.
Contempt matters, seal number 1, Mr. Anumanta Peretti ji. Seal number 1.
Your Lordship, appearing for the complainant.
What do you want?
Please, Your Lordship. Your
Withdrawal or
Lordship.
rejection? Interim order, we are not going to enter.
Your Lordship,
It is interim order.
please, Your Lordship. But Your Lordship, we have, if Your Lordship may kindly see from annexure E1 to E10. In the,
Not see.
please, Your Lordship.
Let the learner single judge see.
Your Lordship, if Your Lordship can, in the present facts of the circumstances, Your Lordship, the present petition, the complaint has been filed against the interim order dated 9/5/2023. Then if Your Lordship can kindly see the present interim order, Your Lordship, I'll just take 2 minutes. Your Lordship, the annexure A.
The order brought under the contempt jurisdiction is admittedly an interim order wherein learned a single judge has only issued notice and granted
Yeah,
to restrain the respondent from creating third-party interest. The entire controversy on its merit is at large before a single judge. Full stop. No rights of the parties are finalized. The contempt jurisdiction is not liable to be known.
A humble submission, Your Lordship. In that case, a short accommodation we provided. The arguing counsel shall come and make the relevant submissions before Your Lordship.
Open for the applicant to complainant to work out his rights and remedies in the parent proceedings before a single judge. This petition is dismissed as above.
Number 2, Mr. Eugene Prabhu Bharat.
Obligation.
Yes, who is appearing?
Still number 2.
Two-third.
Still number 3. The Ravindra G. Gayatri.
Appear for the complainant.
Notice returnable on 15 July. Yes.
Still number 4.
Appearing for
Kumar
complaint,
K.
my lord. Appear for complaint, my lord.
Allotment of some plot is to be allotted.
My lord, we deposited the amount, direction to deposit the amount, deposited, sell it was to be executed by BDA. This was a direction case 16, my lord.
Notice returnable on 11th July.
Number 5. The Narendra Gowda.
Though there is specific direction from this honorable court to conduct Quarry and Durasti, till today that has not been done.
Notice returnable on.
Lords, we have filed our
Your file.
affidavit, my lords.
It is complied with.
Please, it has been complied.
Where is the affidavit? Number 3 is directed to carry out the Kodi and Durasti proceedings of entire surrender number 63 within period of.
My lord, I go through the, whether the, I was not aware
Sir, it is
whether
just-
that has been done or not.
We are also.
I'll
not-
verify and it may be taken.
We are also going to verify right now, yes. We are also not our like you.
It may taken up next week, my lord.
So it's paragraph 3. Paragraph 3 of the compliance report, compliance affidavit.
We have filed the RTCs, my lords. RTCs have been enclosed. Wherein 27 guntas land has been entered into the name of the complainant. And another extent of 8 guntas.
I have not furnished any there. Let them furnish, I'll go through, my lord, and it may take up next.
Go through right now, it is done. To give copy to the, your counterpart. Go through.
Taken up next week, my lord, because I will verify from my parties,
There
because
is nothing, Mr. Counsel. Otherwise, we would have certainly granted time.
just now they are furnishing, my lord.
So what is, read it, paragraph 3, 8.2. It is submitted that A.B. Chandrasekhar, yourself,
Please.
had approached the Tehsildar and they are requesting to make Durasti work and to enter their names in the plan record. Representation was given. Records pertaining to K.B. Chandrasekhar, Durasti and Kodi work was conducted. And the old RTC number, which was 63, is now changed to new number 266 and 267. copy of the RTC and mutations are produced. So that marks the compliance.
With liberty, if in case of any lacunae, there might be with liberty to file a fresh.
What remains, anything remains?
Please.
Anything remains? Anything remains for liberty? Alone a single judge in order dated 7/10/22 issued following directions, which are sought to be complied with by filing this contempt petition. So these are yellow. Everything will be available from compliance. Full stop. In response to the notice, learned additional government advocate Ms. Pramodini Kishan appeared and filed compliance affidavit stating thus in paragraph 3 and quote paragraph 3, full stop. The above amendments along with the above amendments coupled with the fortifying documents go to show that the directions of learned single judge are complied with. No further, the present proceedings do not require to be continued as the orders are complied with. Contempt proceedings are disposed of as not surviving. Full stop. Learned counsel for the complainant, Mr. So and so, submitted that if that liberty is reserved for the complainant to move the court in case of difficulty. Full stop. While the present contempt proceedings are closed, if any independent grievance arises in respect of the body and durability undertaken, it will be open for the complainant to institute separate proceedings to be considered in accordance with law and on its own. Contempt proceedings are disposed of accordingly. Yes.
Thomas.
Appear for the complainant. And my request for a week's time, the counsel from Bombay would be coming to argue, my lords. The counsel on record is not there today, my lords.
This is interim order.
My lords, the interim order is that, my lords, that they were not, they were to be, the interim order is that the order of the award passed by the labor tribunal was to be stayed. It was stayed, my lords. Thereafter, being aware of the fact.
17B order is there. Please, subject to compliance.
Please, my lords. It's been extended from time to time, my lords. Being aware of it, they go before the labor commissioner and take an order of prohibition of unfair trade practice, my lords, when there is an order already operating.
Sorry, it is the following order right now.
My lords, it's my at least request, my lords, to have it on Monday. The counsel on record would come and argue before the lords.
We are not, as a matter of rule, almost in all cases, unless the order is scraping of finality, entertaining the contempt against the interim.
But my lords, they go before the labor commissioner when the learned single judge of this honorable court had
It is
stayed
the following
operation.
order which is brought under the contempt jurisdiction of this court invoking the provisions of contempt of courts of 1971, page 19 order. Full stop. Evidently, the aforesaid order is interim order, whereby the stay is granted by a learned single judge, subject to compliance of the provisions of section 17 capital V of the Industrial Disputes Act 1947. Full stop. The entire controversy is at large before the learned single judge in the writ petition. Full stop. The final rights and obligations of the party are yet to be worked out on merits. Full stop. And the paragraph, when the order is interim order and no final rights are crystallized, the court is not inclined to exercise its contempt jurisdiction.
May be given liberty to urge before the single judge, my lords, as to what has
Therefore,
been
this
violated.
contempt application is not entertained. However, liberty is reserved for the applicant to approach learned single judge in respect of the grievance raised in this contempt petition to work out the rights and remedies in the state proceedings.
Great. Bless.
This court does not express any opinion on the merits of the case of the petition.
Bless.
This is number 7. The party in person, Y.S. Arun Kumar.
Yes,
Number
Your
7.
Honor, I'm Arun Kumar,
Yes.
party in person, Your Honor.
Yes, somebody wanted time here? You wanted,
I was about to appear for still number 8. My apologies.
you are in 8.
8.
Yes, Mr. Partin first.
I'm Arun Kumar, party in person, Your Honor. I had filed a writ petition in case number 17946 in 2019, Your Honor. At page number 16,
Third learned party in person, notice returnable on 23rd July. Next.
thank you, Your Honor.
Number 8. To Vaibu.
I request for short adjournment.
Why?
On record counsel is not in station. I don't have the on record counsel is not in station, and I don't have the file also.
Who is out of state?
On record counsel, my lord.
Counsel. What is the contempt? Tell us. What is the contempt? What is not complied with?
Lord, the order of the learned single judge, my lord, the final order.
Which direction not complied with?
Sorry, my lord, I don't have the file house.
After 10 days?
Please, my lord.
Number 9.
Complainant in the matter, my lord. I pray that notice may be issued to the complainant, to the accused, my lord. For the complainant in the matter, my lord. This petition has been filed as against non-compliance of the order of the learned first additional senior civil judge, my lord. Bangalore Rural Court. My lord, in fact, pertaining to the matter, there is also a Supreme Court order, my lord, of 3/1/2024. Lord, Lord, the my lord, I pray that in this matter, notice may be issued because there are 2 writ petitions which are also pending on the same point, which have been listed tomorrow, my lord. I can give the writ petition numbers. My lord, the fact is that the accused has not followed the order of the lower court, wherein there is a detailed order where we were supposed to get visitation for about 10 days in summer, and then 10 days for the rest of the holidays. That order has not been complied with. I only got visitation. I didn't get custody, my lord. So they are in contempt, and on the same point, there are 2 writ petitions before.
You challenge this order.
Yes, my lord. Yes, my lord.
You yourself have challenged.
My lord.
You have challenged this very order.
Yes, my lord. Yes,
because the custody is not given.
Yes, my lord. Yes, my lord. So I pray that notice may be issued, my lord.
This is interim order, not the main proceedings must be custody proceedings are not finalized.
My lord.
They are finalized?
My lord, they have not complied with.
Today, what do you want?
My lord, today I pray notice may be issued to the party to appear in the matter because the writ petitions are already posted tomorrow.
Which writ?
There are two writ petitions pertaining to the same matter, which is preferred by the accused to only.
Let all petitions come together tomorrow.
My lord, yes, my lord. Much obliged.
Number 10. The PL matters. The Siddhamalappa PM.
Seeking permission to appear on behalf of Siddhamalappa. It's undergone eye operation. Lord, this is public interest litigation Lord, a pure residential locality.
You show some provision where the bar is not permissible
Yeah.
in
Rules.
the
Rule,
residential area.
rule for you, residential locality, they cannot, my lord.
Let us,
Yes.
there are rules or what guidelines?
This is rules, my lord.
Which rules?
Rules, rule 5.
Of
The Karnataka Excise General Condition of License Rules, 1967. There is one school also,
school and temple and everything.
temple,
That is what
but
we are-
it's a pure residential locality, and then building also, Miller, where license has been given, that is also residential building. They have played some mischief and they took e-kata, but it has been dismissed. It is not a commercial building also, but purely residential locality, Miller, it's really a case where your lordship interference is required, Miller. In spite of the residents' objections, Miller, they have given a endorsement at Annexure D, stating that school is within 130 meters.
So page 62 is an order rejecting your representation.
Millard, Annexure D,
D, yes.
page at,
Yes.
translation page at 42,
62.
relevant portion,
62 or 40?
42.
40.
Relevant portion at 43, last paragraph. May I draw your last attention?
1 second. Oh.
I read the reason which they have assigned.
No, this is pursuant to your representation.
Please,
Ah.
please.
Please page 62.
62.
9123.
There is no 62 in my page.
That is the order which you are seeking to set aside. Page 90, page 62, Annexure D. In your prayer, that is the order referred. Page 62, Annexure D. That is the order with which you are aggrieved.
No, my lord, I'm sorry.
Go to page 62.
62.
There is no 62.
There is 62.
Yes, 9120.
There is only 48 pages.
That is in the
Any
chair.
mistake? Left in, because it is my colleague's case.
What kind of colleague you? You giving half papers.
No, there is no such page.
Or like, you want time?
Petition, I'm sorry if there is.
Doesn't matter, you want time.
Huh?
You want time. But they don't have the remedy of appeal.
My lord, my lord was pleased to dispose of similar matters because there is a provision for appeal under section 61(1) of the Karnataka Excise Act, my lord.
Section 51.
61.
61. So that is the, that is, That is how in fact the matter stands. You may be right in your grievance. We don't know. but
Grievance has a public interest, my lord. There is no personal
When there
interest.
is a remedy of appeal, we will not entertain public interest.
With that observation, your lordship, kindly I may be permitted to prepare an appeal. Because they are
Very
not
good. Very good.
if the,
But learned-
my request is if take it as a public interest, in the future also they will avoid to do that such things.
We'll make some innocuous observation in your favor.
Please.
Yes. The present petition is in the nature of public interest petition, in which the petitioners who are the inhabitants of the residential society, whom I have raised grievance about granting of license to whom?
The respondent number 6.
To respondent 6 to open and operate the bar restaurant. The presentation of the petitioners objecting to the decision to permit the bar restaurant came to be rejected by order dated 9/1/23, which order is prayed to be set aside. It is further read to direct the respondent authorities not to permit and not to issue fresh CL-7 license to run a bar and restaurant in the premises of respondent 6, which is Khata assessment number 3271/3271/1/capital A. The precise case of the petitioners is that the bar and restaurant to run the business of vending alcohol is permitted in the residential area. It is stated that where is your stated distance? Different
No,
distance. Yes.
Annexure D, they have stated school is within the 130 meters.
Where is that?
Annexure
Yes, yes, where is that? Annexure?
D.
Page?
D, page at
I saw, but now not
44,
able to-
44, 44. 1, 2, 3, 4. Fourth line from the bottom. May I read? Ma'am? Since there is a distance of 130 meter, there is no objection placed as per rule 5. They don't deny it is a residential locality. They have taken only regarding school.
That there is a residential colony from residential colony where the bar is permitted, and that the educational institution, namely Swami Vivekananda School, Kunigal, is also situated in the vicinity. It is also stated that the temple is also located nearby where the restaurant and bar is going to be permitted to be opened. Full stop. In support of the case, learned advocate for the public interest petitioner relies on Rule 5 of the Karnataka Excise Licenses into bracket General Conditions, Rules 1967, which reads as under, then Court Rule 5, full stop. It was submitted on the basis of the, after quoting above rule that the license for sale of liquor is not permissible to be granted within the distance of 100 meters from any religious or educational institution or residential locality where the inhabitants are predominantly belonging to scheduled caste and scheduled tribe, or within distance of 220 meters from the middle of the state highway and national highway. Full stop. learned additional government advocate, Mr. Nilofer Akbar, on the other hand, submitted that. the
My lord, may I
petitioner
make
has-
one submission? I apologize. My lord, the endorsement is dated 9/1/2023. My lord, section 61(1) provides that the appeal has to be filed within 60 days from the date of receipt. Now, this is coming up before my lords in 2024. The date of filing, I think it is in 23. My lord, it is scanned on 14/3/2023. My lord, I'd like to bring this fact to the notice of my lord and leave it.
Earlier, my lord, the writ petition was filed, I think so, my lord.
There is a judgment of the Supreme Court in relation to election petition, where on the ground that the petition was filed
Yes.
before the High Court said that when you file election petition, it will be treated to be within time, to be reckoned from the date of disposal of the writ petition.
My lord, since this is a statute, I've just brought it to the notice of my lord so that this should not send a precedent in other matters.
Submits that the remedy of appeal is available to the petitioner against the impugned order dated 9/1/23 under section 61 of the
61(1),
61(1) of the
Karnataka Excise Act.
Karnataka Excise Act 1965. At the same time, she further points out that the limitation is provided for appeal under the said provision. Full stop. The petitioner could have approached the appellate authority in relation to his grievance. Full stop. When the remedy of statutory appeal is available, the court would be loath and disinclined to entertain the grievance in public interest petition and will not proceed to adjudicate the issue in the public interest litigation. Accordingly, the petitioner is permitted to file the statutory appeal available under the Act as above. Full stop. As regards limitation, it is to be observed that the petitioner had filed previous petition as well, which was SCA number, which was writ petition number 415/2023 in the same subject matter.
Yes.
Thereafter, the present public interest bill is filed. Full stop. The time consumed in litigating the said previous petition as well as the present petition shall be treated as bona fide consumption of time to be counted accordingly while reckoning the limitation period if the petitioner opts to file statutory appeal. Full stop. With such observation and further observation that the appellate authority, if the appeal is filed, will duly consider the case of the petitioner on its own merits and in accordance with law, having regard to the operational impact of Rule 5 relied on as well. Although this court does not express any opinion on merits, disposed of accordingly.
Much obliged.
My lord, even otherwise it's barred, my lord.
Prima facie is there entirely right. Therefore, this.
They haven't come at the earliest opportunity, my lord.
Seal number 11.
My lord,
Hanumanta Parvigowda.
I am for the petitioner, my lord. My lord, earlier the petitioner had been before this honorable court in WP number, my lord, annexure F, page number 51, 44740, wherein seeking a direction. Next, F, my lord, next, page number 51. That this honorable court has disposed of writ petition and basing on the submission made by the government advocate, my lord, page number 52, my lord, wherein second parameter. Annexure F, page number 52, second parameter. The learned principal government advocate appearing for respondents submits that special provision is made for Hyderabad, Karnataka region under Article 371J of the Constitution of India. He submits that the development board is already created for the said region. The submits that the equitable allocation of funds for developmental expenditure over the said region is also being made. With that observation, it person disposed of. Then, my lord, the petitioner has made representation on G, my lord, page number 54, not properly implementing the scheme of the report submitted by the Dr. Nanjundappa committee, my lord, to avoid imbalances of development in the state. Next, G, my lord, page number English version copy, my lord, page number 58. This is the English version copy, my lord. This representation not till date not taken action by the respondent, my lord. Despite order, this representation made. The government is bound to consider the representation right of the report of the Nanjundappa committee, my lord, to avoid imbalances in the state. Establishment of the industries in the state, my lord. That North Karnataka is a totally backward area, my lord. That's why the Nanjundappa committee is recommending the government to establish industrial areas, to provide employment and also to the younger generation to come on the mainstream.
So what are the earlier order?
That is the, my lord.
Page 50.
Allocation annex F, my lord, is. Annex F, my lord, the page number.
Because that was based on the same report.
Please, my lord, on the same report. The same report, madam.
So then what more do we want now?
No, my lord, despite this order, the government has not provided any funds to the area, establishment of industrial areas, my lord, or industries.
This order was passed on in 2014.
19th September 2014, my lord.
So what we were doing for 10 years? You could have filed contempt if funds are not allocated.
Because of the government is always bound to follow the order of the government, my lord. The keeping quite.
But prayer is not for providing funds.
Please,
Your prayer is different.
Please.
Your prayer in this
Please.
is different.
The constitution of the annexure, my lord, G, representation, annexure G it is.
What is the prayer? Not for funds. You want establishment of industrial area.
Please.
So that is entirely. How can the court force them to accept the report? If they want to accept, they may accept the recommendation. If they don't want, we can't say that we establish industrial area here. Is it our function?
It is the duty of the government, not as per the submission made by the earlier person, the providing funds and also the establishment of industrial areas. But till date, no action taken by the responding government.
Maybe a duty, but there is no enforceable right for you to urge that duty in public interest litigation. It is their own function, their own discretion whether to act upon the recommendation of the report or not.
Let them pass an order regarding the implementation scheme, my lord. Because, my lord.
What do you say?
He's not entitled for. My lord, I think there's a writ petition earlier
What has happened to this report?
My lord, I'll have to seek instruction, my lord. It's coming up for the first time.
Seek instruction.
Right.
Not recording anything.
No,
Seek instruction. We are soliciting instructions.
My lord,
We are soliciting instructions from the council.
please, my lord, please, great.
10 or 2, next Monday, Tuesday.
my lord, 2 weeks time because
weeks.
officers have to come in after reporting
Will-
from elections, my lord.
June.
Great, my lord.
December 12, Sharat Kumar Shetty.
Writ of mandamus speaking to consider the representation of annexure F. Here what happened, your lordship, the sixth writ of mandamus, your lordship, to consider the annexure F, your lordship. Here, your lordship, the sixth respondent.
Annexure F.
Annexure F.
What is
The-
it?
The sixth respondent is the elected member. He has allotted all the work to his son, which is against to section 43A5 of Panchayat Act, your lordship. We have given several representation, but none of the representation is considered by the first respondent to fifth respondent. And we are requesting your lordship takes action against the sixth respondent because he has assigning all the work and the 15th commission is entire amount is sanctioned to his son without any committee meeting, without any permission. Annexure of your lordship, the clearly says in para 2, from moment your lordship, page 28. Ma'am. The fifth respondent admitted your lordship, the amount has transferred to his son account, the first para, your lordship, page 28. May I, your lordship, remove?
Who are you?
So I am the villager, your lordship. I am the villager, the same village, same village.
Sorry, heard learned advocate Mr. So and so for the petitioner, paragraph. The petitioner projecting himself to be a villager and public spirited person has filed this public interest petition seeking a prayer to issue direction to the respondent authorities to consider the representation dated 3/1/23 and to remove the sixth respondent, to remove respondent 6, who is the member of the panchayat. It is further read to direct respondent number 2 to 5 authorities to make an inquiry against respondent 6 in respect of the alleged misappropriation of funds and alleged acts of corruption. Course of the case pleaded in this public interest litigation is inter alia that the son of respondent 6, one Vishwanath, is a contractor in the same village, and that he is favored in matter of sanctioning of the work by the panchayat, since this respondent 6 is the member of the panchayat. Full stop. It is alleged that it is alleged that respondent authorities have failed to take action against the misappropriation of funds against the contractor and in respect of the work undertaken by the said contractor. Full stop. The petitioner has given provided list of works which were assigned. Full stop. The averments in the petition paragraph are too general and too vague to be countenanced. Full stop. Except generally alleging that the son of respondent 6 is favored in the matter of allotment and sanction of work, no details except listing of different works during the different financial years are provided in Annexure B. Full stop. No details are provided as to the alleged corruption or misappropriation or any other irregularity. Full stop. Even a semblance of details is not available in record, on the basis of which, even by inferential process, it could be accepted that the inferring process, the submission of learned counsel for the petition could be accepted. Full stop. At the same time, paragraph. At the same time, the representation of the petitioner is pending, there is no reason to presume that the competent authorities who are obliged to act in accordance with law, would be oblivious to the duties they may require to discharge. Full stop. It is expected that the authorities shall look into what is generally alleged in this petition, and if considered, and if any material is found, necessary action may be taken. The present public interest petition is dismissed, subject to above limited observation. Yes.
I had mentioned about a writ petition, my lord. Writ petition that was also connected to the matter. My lord, the writ petition has been partly heard by the honorable judge. So I request that in this matter, notice may be issued, my lord, and
gone now.
Lordship, may I just add, Lordship? I'm appearing in this matter also. There was some connection issue previously. May I submit, Lordship?
Once matters are gone and orders are passed, they never come back, like time.
Lord,
So
I'm very
come
sorry,
tomorrow. Come tomorrow.
Lord, I'll make a mention. Much, Lord.
December 13,
Yes.
Green Bench PL matters.
Appearing for petitioner, my lordship. The petitioner is seeking for a writ of mandamus, my lordship, directing the respondent authority to consider my application for grant of the quarrying lease. My lordship, earlier occasion, the authorities.
Given see that you are again seeking the forest clearance.
My
Revision application is allowed.
Yes.
And according to the case of the petitioner, the forest, no objection was already granted once.
Yes, my lordship. Once it has been
You
granted.
are again re-insisting. We don't know whether it is required or.
So my submission is, this application was rejected in the year 2016 in view of the amendment brought into the Karnataka Minor Mineral Concession Rules on 12/8/2016. Now the review against which Milord he has filed a revision. Revision was pending. In the year 2023, that is 17/3/23, again an amendment was brought in. This says all the pending applications shall be reconsidered. In view of that, Milord, revisional authority directed the competent authority to consider the application. Whereas, Milord, in this particular case, it is not a pending application as on the date of the Amendment Act 17/3/2023. It was rejected application. So the question of reconsidering it does not arise. I'll seek instructions, Milord, and file my statement.
Already Joint Director, my lordship, has remanded the matter. When he has
Accept
it
notice.
has been remanded.
Heard, learned Advocate Mr. So-and-so, the petitioner. Notice returnable on 12th on
3 weeks time.
9th July. Learned Government Advocate Mr. Mahendra waives notice, accepts notice on behalf of this member so-and-so. He shall file statement of objection, public reply, affidavit before the next date.
Number 14, RG Kolde.
Please, my lords. In the year 2008, I had applied for a grant of a quarry lease over an area of 8 acres.
8 acres. You
8
gave up,
acres.
you gave up 5 acres. You consented to give up 5 acres. And that is the order. What more requires? You yourself consented before the authority to give up 5 acres. And 3 acres is granted.
Yes, but my lords, my submission would be, Deputy Commissioner has personally visited the site and recommended for the grant of 8 acres.
Now, you can't enforce your voluntarily accepted obligations.
We have not voluntarily surrendered, my
It is voluntary in so many words, in so many.
No, with a view to grant me all 8 acres, my lords, I was asked to surrender it because there is no provision to surrender the grant notification. What can be surrendered is only quarry lease. But under an erroneous assumption, the departmental officer said that when there is a grant notification for 3 acres, it cannot be granted for the second time for 8 acres land. That's why I was asked to return the grant notification of 3 acres. And in between, after 12/8/2016, the task force committee, without authority of law, got into the arena and said that you conduct fresh measurement. That is impermissible under law. When the deputy commissioner himself has personally visited and said that 8 acres land is available, freely available for grant, for which forest NOC was also received. Technical report was also received, my lords. It became a saved application. There remains, for the second time, the additional deputy commissioner and the DDLR and junior geologist going there and say that it is within a distance of 170 meters, my lords. And that too, based on a Google measurement, they came to error. They never visited the spot. That's what is reflected in the report itself, my lords. So whatever is that subsequent things are totally not in accordance with law. That is my submission. So when 8 acres of land is freely available for grant, as has been certified by the Deputy Commissioner in his revenue NOC, and followed by Deputy Conservator of Forest NOC, as also the technical report in Form S, my lords. Exercising a second time measurement or by through Google survey, that is not permissible, my lords. And now also I am making a submission, my lord. Now also they can undertake a fresh exercise, because I made such a request before the revising authority. Revising authority also, no, the competent authority has passed an order. And I never said that I am not interested in the quarry lease.
So only 5 acres notification is surrendered.
3 acres.
3 acres is available.
He applied for 8 acres.
They applied for 8 acres.
8 acres.
Correct.
Since the area of 5 acres is does not satisfy the requirement,
Correct.
now we notified 3 acres area.
He gave up.
3 acres area. Thereafter, he filed an application to cancel that.
Correct.
Gave up.
Correct.
Gave up that in the year 2019 itself.
Correct.
2019.
Correct.
Thereafter, Lord,
19 years.
thereafter in the year 2022, he filed a revision, and in the year 2022, revisional authority upheld the order of the competent authority, cancellation of the notification granting 3 acres of land.
So that
now
is
in the year 2024, this writ petition is filed. Now
You-
it can't be granted.
He wants 3 acres now.
Now he wants 3 acres.
No, I am asking for whatever is freely available without any restriction.
To independently apply, not.
My only submission, my
You are
lord.
independently entitled to, yes, but we can't.
But no,
Now the law is changing.
I may be permitted to advance my submissions, my lord, to say that I, by way of my 2 letters, made it very clear that I am returning my grant notification with a view to get, and as per my area applied as per my QL application. So my submission is whatever is available as per QL application, freely available outside the restricted zone, my lords, I'm happy with that, my lords.
Independent of this petition, you may apply.
Now the question of applying does not arise.
Because
That's
auction.
Auction. 2008 application. This is the application of the year
Oh,
2008.
that door is also closed.
No, my submission, I have gone in revision, my lords. Revision just recently, last month only, I think it
The
is
year 2022.
22.
revision.
Yes, immediately after that, I have filed this well within the period, my lords. That annexure A is the order passed by the revising authority, my lords. Challenging that revising authority's order, I am before my lords. I am purely seeking leniency from this honorable court, my lords. Because she is a lady, under a mistaken and erroneous assumption, whatever the departmental officers have guided her, she has done it, my lords. And while, so I think writing those 2 representation, my lords, the intention was to return or surrender, whatever, call it by whatever name, to get the entire 8 acres applied area.
We want you to come with a petition where you don't argue and we grant stay.
Beg your pardon?
We want you to come with a petition where you need not to argue and we will grant stay.
Sorry, my lords. It's not the case, my lords.
Sorry, Mr. Hard learned advocate, Mr. What is your good name?
Otherwise, it may be kindly.
Indra Gajanan Kolle, for the petitioner and learned government advocate, Mr. Mahindra, who appeared upon service of copy of the petition.
But my own submission, my lords. So it may be remanded back to the competent authority for, based on the revising authority's order, for fresh consideration. Even if it is 3 acres also, it is okay, my lords. I am happy with that, my lords. Now, without going for further other things, only discretion may kindly be granted.
The petitioner, by filing this petition, seeks to address challenge to order dated 15/6/22, passed by respondent 5, the revisional authority. as well as order dated 4/6/19 passed by respondent 4 dash the senior geologist and competent authority, from which order the revision arose, full stop, by the said orders, comma, the requests of the petitioner for grant of quarry lease in respect of 8 acres of land pursuant to petitioner's application apostrophe S dated 22/6/2006. Came to be negative, full stop. A further prayer is made to direct S114 senior geologist to restore the grant notification issued in form GL capital dated 10/8/18 in respect of area of 3 acres of land in survey number 47 of Bettahali village, Malur Taluk, Kolar district. Full stop. It appears that the application of the petitioner, paragraph. It appears that the application of petitioner for grant of ordinary building stone quarry lease dated 22/6/2006 was initially made for the area of 8 acres of land in the aforesaid survey number. The survey thereupon carried out by the competent authorities revealed that the said land was not grantable since the parameters were not satisfied. Full stop. Ordered it paragraph, ordered it at 4/6/2019, passed by the senior geologist, recorded that in view of the joint survey report of the Department of Land Records as above, comma, the applicant gave consent and signed the Mahazar MAHZAR to reduce an extent of 5 acres and accordingly grant notification. Grant notification received in favor of the petitioner for remaining 3 acres. Full stop. However, the applicant petitioner refused to accept the said grant of 3 acres and requested on 23/5/2019 to surrender the said notification. The aforesaid facts are not in dispute and are matter of record. Paragraph pursuant to the withdrawal and the request to surrender the notification given in respect of 3 acres of land, comma, the senior geologist passed order dated 4/6/2009, whereby the notification issued in respect of the said area of 3 acres was surrendered. Full stop. The petitioner paragraph proceeded to challenge the said order before the revision authority in the year 1920. Full stop. The revision proceedings culminated into impugned order dated 20/4/22. Full stop. The revision authority noted that the grant of quarry lease in respect of 8 acres of land in the survey number was not grantable inasmuch as the area was located at a distance of 160 meters from the village, 70 meters from the temple, and 30 meters from the lake, as also 170 meters from the school. Full stop. The safe distance was required to be maintained from those locations, which was not possible. Therefore, the request for grant of 8 acres of land was not liable to be exceeded to. Full stop. It was the reason reiterated that the notification for 3 acres of land was issued by the competent authority, after the consent of the applicant. However, subsequently, the said notification for 3 acres was also requested to be by the requested was surrendered upon the request of the petitioner itself, as the petitioner, this applicant showed that applicant stated that he was not interested in conduct of quarrying activity. Full stop. It is the aforesaid orders which are now brought under challenge in this writ jurisdiction before this court. Paragraph. As noticed above, as noted above, comma, the petitioner was held entitled to the grant of 3 acres at the relevant point of time, and the necessary notification was issued. However, the petitioner did not accept the said notification and requested to cancel the same. Full stop. The petitioner did it voluntarily, pursuant to which the competent authority surrendered and cancelled the notification. Full stop. The petitioner is seeking to revive the request. Paragraph. No case is made out at all. Full stop. The writ jurisdiction cannot be invoked to enforce the voluntarily incurred obligations, which was, in this case, the request of the petitioner himself to surrender the notification and not to have the quarry lease for 3 acres. Full stop. When the petitioner himself has stated so, and thereupon the notification was cancelled, comma, no remedy could survive for the petition to be enforced before the court of law. The petition is entirely misconceived and is dismissed with cost of rupees 5,000.
My lord's discretion, my lords.
Dismissed. Yes.
This is number 15, Mr. Prakash BS.
This is like yesterday. Who appeared? That 90 days are over, but you are not deciding.
No, that 22, rule 22 is repealed. It's not there.
Now it is not. But then you decide irrespective of that rule 20.
And moreover, this is an application of the year 2013.
That 90 days rule is repealed?
Yes.
From where? From when?
From that
2016.
12/8/2016 amendment.
No, this is not a
But then
non.
irrespective of that, the grievance is that you are not considering the application.
Lord, the question of considering the application does not arise because by virtue of the amended rule 8B(1), all the pending applications become ineligible. There are certain exceptions are carved out under 8B(2).
My lord, my lord, the rejection what is said
Now let
was
us
challenged before this honorable court.
let us see what is your prayer.
Please. my lord. It is to consider my application within a time-bound manner, my lord.
Which
That is
that
all I
ap-
have sought, my lord.
Which is that application? Annexure A.
Application annexure A, my lord.
Yes. So that was an application dated,
2013, my lord.
but then 8B will take care of your application.
Please, my lord.
Newly introduced provision of section 8B,
Ah.
rule or section rule.
No, that was, my lord, they issued an endorsement stating Rule 8B, quoting
Rule 8B.
It was challenged before the division bench of this honorable court, which was set aside, my lord. Therefore, the application was revived again.
Allow the rule. So now the applications will not survive. They are lapsed.
By operation of
And the
8B(1).
policy is to grant by auction
Yes,
pursuant to 16 rules.
yes.
No, that rejection order what they given, my lord, under that particular rule was challenged before this honorable court, my lord. The coordinate bench of this honorable court was pleased to allow the petition, set aside the order of rejection, my lord, and directed to consider afresh, my lord. Directed the respondents to consider the application afresh. Such application is still pending. That is my grievance, my lord.
Which application? Let us see. Who directed to reconsider?
Please,
Spell it- spell it
three,
out.
four, fifth paragraph, my lord.
Doesn't appear to be correct.
Paragraph 5, my lord.
Paragraph 5 of page,
5, my lord, page 5.
page 5. Let
May
us
I
see.
read, my lord?
Yes, please.
That the petitioner submits that being aggrieved by the rejection of the quarrying lease application by the respondent on an erroneous application of the rules, the petitioner approached this honorable court with petition number 34822 of 2017 for the redress of its grievance. The honorable court by its order dated 7/8/2017 inter alia disapproving the action of the respondents in rejecting the application directed the respondent to seek opinion of the concerned authorities and to decide on the prayer of the petitioner for execution of the quarrying lease within a period of 2 weeks. So such rejection was set aside.
This situation arises in all many cases. So how to deal with them?
No, my lord, my submission is, there need not be an order.
They are saying that if they ultimately succeed, then it will revive from that interior rate. If they ultimately succeed against in respect of their challenge to rejection, and the application is revived, then that revival will be from the interior rate before the date of coming into force of 8B. So it will have to be treated as pending application. That is perhaps they are arguing.
The 8B1 clearly says, whatever the pending application prior to 12/8/2016 are become ineligible in clear words. There need not be an order passed in that regard. The only exception carved out.
Even if they succeed before the authority, they will go. Even if they are succeed.
Because by operation of 8B1, it become ineligible as on 12/8/2016 itself, is
Then
my
my lord,
submission.
this order of this court will be nullified if they're what saying, my lord.
Which order?
34822, my lord. That was set aside.
It is not unknown that the orders of the courts are nullified of operation of legislation.
So therefore, by that order, my lord, the application is revived. So even if they have to disagree, my lord, they must agree first, my lord. Let them pass in any order, my lord. But they can't seek an order here, my lord, in this writ petition. Because my only request is consideration. (2023) amendment.
Received and pending. So it was received and rejected.
It's not rejected, it is pending.
Was rejected.
His application.
They gave an endorsement stating that as per the rule 8B,
His
the application is rejected.
His application was rejected.
No, this is, I think, 34822 of 2017 is what he is mentioning.
Yes. In that writ petition, the order of rejection was challenged, my lord. The order of rejection based on rule 8B issued in favor of the petitioner was challenged in this writ petition, my lord. This honorable coordinate bench of this honorable court does not approve the rejection. Therefore, that order was set aside, my lord, the rejection order. The application again become revived, my lord. Even in the year 2023, an amendment is carried out to the said rule, my lord. At page 7, my lord, 34822.
Lord, if it is in pursuance of the order, this 34822 of 2017, setting aside our order,
Of rejection.
then we may have to consider the application because it's not rejected. That order is not produced by the petitioner.
What is rule 8.5 and 8.6? Rule 8.
8.5 mandates, my lord, they should obtain the no objection certificate, my lord. It casts a duty on the competent authority to consult and obtain the
In case
no objection certificate within a specified time, my lord.
But they will obtain such a certificate
8.5, if they don't obtain,
in respect
8.6,
of some application which is pending. Is your application pending? You
it was
want-
pending, my lord. Yes, my lord.
No, you want them to obtain these certificates under rule 8.5 and rule 6,
Ah,
8.6.
yes, my lord.
In respect to which application?
In respect of this application, my lord, 2013,
Where is the? It is
Annexure A, my lord, Annexure A is the application, my lord.
31st.
Please, my lord.
Where did it survive?
Please, my lord. Yes.
There is some.
that's not
Pardon?
this one. I was under the impression, Lord, my instruction is application is pending. I never knew that, Lord, because of this direction of this court. If the application is pending, Lord, we'll consider and pass appropriate order.
Please. This is the order.
That was the first impression when I read the matter.
Please.
You are bound to consider. Don't know in which way we don't.
Yeah.
13 application was pending. 13 application Mr. Mahindra was pending. Therefore, it was received. And therefore, as my brother is pointing out that first proviso to rule 8B will apply. Possible. Read it. Read first.
As substituted by this amendment.
Substituted.
2023, the rule has been substituted, 8B.
8B.
8B. With effect from 17/1/2023, it has been substituted. So say all applications.
That is what we are saying.
Please.
8B is first proviso.
Please, please,
We'll pass order tomorrow. Let us understand at least,
please,
so that better reflection come in the order.
please.
But it appears that we will direct you to consider in accordance with noticing all these provisions. Tomorrow at 11.
Please.
Not in one of the matters, this honorable court took a view that if the application is rejected prior to 17/3/2023 amendment, that those applications are not saved application to be considered in view of 17/3/2023 amendment.
Correct.
That has to be considered.
But here it is pending. Isn't it pending?
It is pending.
It is pending.
Thank you.
Tomorrow, Mr. Council will pass the orders. Give me. Tomorrow.
Please, please.
So new sub-rule 5 of Rule 8 as amended will apply. Correct?
Rule 8.5 is there from the beginning, my lord. It is there, it is
Not
not.
of all rules.
It is old, also new is there, my lord.
So new will apply.
Please.
Only difference is this, my lord. 17/3/2023 substituted provision will apply for the pending applications only.
Correct.
Those applications which are rejected,
Correct.
that cannot be revived by virtue of 17/3/23.
True.
Here, though it was rejected by the intervention of the court, this honorable court, since it has been set aside, the application is pending, we have to consider.
That is the whole.
That's all.
One is, my lord, may make one submission only, my lord, with reputation, cost of reputation. By operation of the government, we contends that by 8B, my lord, by virtue of 8B, as on 12/8/2016, if the applications get rejected, my lord, by express provision of law under 2023 substitution, my lord, it gets revived, my lord.
In fact,
17/1/2020.
In fact, his application is only to direct the respondents to consider the application.
Yes. We'll consider in accordance.
Please, my lord.
Tomorrow.
Please, my lord. Please, my lord.
Get the copy of two copies in.
Number 16, still empty done.
Here for the petition. And I'm sorry, my lord, outside. That Rule 22, which I relied yesterday, is omitted, my lord. Your
Which
lordship.
one? 16?
Yeah, 16.
Lord, this is covered, not covered. 6 months time may be granted, we'll consider.
Yesterday, I gave the copy to your lordships.
Covered.
Yesterday, I gave it to your lordship, those same copy. Yesterday, I gave it to your lordships. It is there in the file.
On seniority basis, Lord, application will be considered.
Same line.
Same lines.
Please.
Disposed.
Please.
Do 16.
Okay.
Regarding complaints in contempt matters, SL number 17.
Yes, counsel for the complainant. It's a matter where, my lord, administration of a B grade temple has been taken over by the government by appointing administrator. The order was set aside. While taking over the management, clear merger was drawn. The assets, everything was, my lord, properly merged, and the management was taken over in that fashion. But now, once it is set aside by the single judge, and the same has been upheld by the appellate court, my lord. Now we are in contempt, my lord.
By the apex?
No. The division bench of the court.
So it is final.
No. It has been upheld. The writ appeal also dismissed.
So it is final now.
Yes, my lord. Finally. Now it is in contempt, my lord. Now they just gave a letter saying that administration is given back. This may not be proper, my lord, because for this reason, the assets, my lord, the jewelry, the ornaments, my lord, and the temple keys, hundi, everything has to be accounted and handed over. The manner in which they have taken the possession has to be restored. That is the spirit of the order also, my lord. For each and everything, my lord, we will not be in a position to file a writ petition in such direction. The only remedy, my lord, which is available, even, my lord, the direction, the respondents are directed to hand over the administration to so and so. My lord, the original petitioner, my lord, died during COVID, and his one son also died. Now the surviving hereditary trustee is, my lord, the present applicant, the complainant. Therefore, my lord, all that we are saying is, my lord, the manner in which, my lord, the merger was done, we have filed along with the counter affidavit. The lordship may get in page 30 of the counter affidavit. Each and everything, my lord, the ornaments, everything was weighed, and, my lord, in the presence of panchas, it was taken over. Now they simply give a letter saying administration is given back. Page. My lord, page 30 of the counter affidavit filed, my lord, on 15th April. Annexure D, sorry. Not Annexure D is the merger. That page, my lord, a translated copy, your lordship will get in 21. This is how the merger was drawn. It was in the presence of goldsmith, my lord. The ornaments were weighed, my lord. Page 21 of the counter affidavit. And tomorrow, if any, my lord, ornament is missing or anything happens, my lord, blame will be on the petitioner, the complainant. Let them, my lord, do the merger and hand over in a manner in which they have taken. That is only, my lord.
So respondents are directed to hand over the administration to Sri Shamanna.
Yes, my lord. Shamanna
Shamanna
passed
is
away
deceased.
during the
His son,
my lord,
Divakar.
COVID, he passed.
Petition. Fourth.
Now I am the, my lord, LR, my lord, the
So
hereditary
this-
trustee.
It is only this direction which is one of contention.
My lord.
Only this direction you want to comply with.
Yes, my lord. The compliance, my lord, in the sense, strict compliance, my lord. For the reason that, my lord, kindly say Annexure D, my lord, along with
In
the
this, if the lordship will kindly look at the complaints affidavit that we have filed, at page 10, there is an order of the committee, which is headed by the Minister of the Mursai Department. There, they have mentioned that there is a rival claimant to his rights as a hereditary priest. There is also the writ petition which is pending. However, the administration, as per the order, has been complied. Only with regard to the deities, jewelry and the other aspect, your lordship. I will seek instructions in this matter and submit before this court.
Lord, somebody
far-
is
as far as the
claiming hereditary
administration of the
trusteeship,
temple
it is
has
a
been
matter to
concerned,
be
that has been
considered by the
complied.
Rajya Dharmika Parishad. Lord, on the date of filing of the writ petition, my lord, and as on today, my lord, I am the only hereditary trustee, my lord. From my father, the temple administration was taken away. If somebody is claiming, my lord, they have to establish their right and they have to not get an order from the court of law. My lord, in between, my lord, this government authorities, they say there is a dispute pending and all these things, my lord. In order to get over from the contempt, my lord, they simply gave one letter saying they're handing over the. And annexure R1 says, my lord, they are handing over the administration.
Can you take charge of the administration and
Yes,
undertake the inventory?
My lord, I
And if
can-
it is at a variance, then in 2015, and anything you find that irregular thing has happened, you can have your own remedy independent of contempt. In
Yes.
contempt jurisdiction, how can we work out all these things?
all that I'm praying is this, my lord. Let them put back the clock as it was, my lord.
only the
The, ma-
custody.
the manner in which the administration was taken, let it be restored. That's the only, my lord, the request in this matter. Otherwise, that letter will say, my lord, we have complied, saying handed over.
We have handed
Not
over.
even key is handed over. my lord, accounts, my lord, ornaments, assets, my lord, all these things, my lord, properly accounted and has to be handed over in a manner. Some measure has to be done. The contention of the rival claimant, my lord, does not arise because in the very same order of the learned single judge categorically says writ petition is allowed, directed to hand over the management back to so and so.
But he is
And
not-
so far as the claims of the other parties, they are at liberty to work out before the appropriate forum. Kindly see, my lord, at page 30,
If that is the order, Your Lordship,
38.
Your Lordship, will kindly see at page 21 of the complaints affidavit, it's a translated copy, if I may read, Your Lordship.
No, for a moment, my lord, your lordship may see page 37 and 38. The rival claimants also filed writ petition. Their writ petition was disposed of. Page 37, your lordship will get. The petitioners in WP shall be at liberty to work out their remedies in appropriate forum insofar as other prayers in this writ petition. The my writ petition was allowed and absolute relief has been granted. The other, those who are claiming have given remedy. They have to establish before the forum that if they have any right. That is not a reason to, my lord, and now it is clear from the submissions that they are trying to, my lord, only get over the contempt situation. Yes, what do you say?
Yes. A week's time may be granted. I will ascertain as to the assets and jewelry that is there in the custody
We
of
are
the.
of the view that you have to ascertain in light of the order at this R1.
R1.
R1 and that list also.
Yes.
And page 21
Yes, Your Honor.
with the rejoinder, with the reply.
Yes,
So,
That is the list of the articles
yes,
and ornaments.
yes.
no,
Assets,
the
both
page-
movable and immovable, both.
Page
Were,
21 is the
which were,
proceedings of the committee.
Which were taken in custody
Yes,
Yes,
at the
by a
time.
proper merger in the presence of Goldsmith, my lord, and Panchas.
Some Panchanama was also recorded.
Yes, my lord. This
Merger
itself
is
is
a-
a Panchanama, my lord, annexure B.
Mazar is a Pancham.
So take it.
Yes, Your Honor.
This will have to go back.
Yes, sir.
Because otherwise just handing over a letter that you are.
Yes.
Is of no meaning.
Yes.
This will be with all its.
He is performing the pujas and other aspects only regarding his plea now is that only the temple assets have to be handed over to him because he is.
He was totally managing the affairs of the temple. It's a hereditary trustee managed temple. Of course, it is a B category, but it is.
Handing over the
It was
administration right
as
now
on the
that he has
date when
admitted
it was taken
that
over, my lord.
he
The
has
same
admitted that he is
position they
performing
should
the
put
pujas.
back.
As far as the assets are concerned, I will take instructions.
As far as.
The assets and other things, what as per the merger report, we'll take instructions and then we'll file.
Last time also they have taken time, my lord, a couple of occasions for some observation.
In light of the order dated 7/3/24 passed by this court, recording inter alia the submission of learned senior advocate Mr. Arun Shyam for the complainant that only symbolic possession and not the actual possession was handed over, of possession of the temple was handed over pursuant to the directions of learned single judge sought to be complied with, comma. The subject matter and the compliance of the directions were further deliberated today with the help of learned counsels for the parties. Full stop. It could not be disputed that the incidences which are necessary to be observed while handing over the administration of temple meaningfully are not observed and complied with by the authorities. It transpired that the handing of administration, in order to be meaningful, has to be accompanied by the handing over of movables, cash and ornaments.
Yes, ma'am.
Cash, if any, and the
Yes,
ornaments.
yes.
And other items,
Keys also, temple keys also,
including temple
symbolic
keys
it is.
and accounts, which were physically available in existence and taken over in the year 2015.
Yes.
Correct, full stop. Learned advocate, learned additional government advocate, Mr.
Jafar Shah.
Jafar. Rest for time to take instruction and to apprise the court about those aspects, about the observance of those aspects. Stand or to, we'll give on 10th of July, we'll do. 10th of July.
Short date.
Obliged.
He sought only 1 week time, my lord. So he sought a week's time. So
Week's time, we'll give
a
a
short date.
but then it will go to June 27.
Obliged.
Number 18, Mr. Somsekhar KM.
Lord, I appear for the complaint.
18, yes.
Next, we have filed the compliance affidavit. And we have enclosed the endorsement, my lords, issued after consideration of the
Complied-
representation.
Complied with?
We have filed.
Lord, they
my
have
lords.
rejected our request for
It was only
restoration.
representation to be released.
Yes, my lord, the honorable single judge is directed.
The
to
only
consider.
direction to be complied with issued by learned single judge was about deciding the representation. Today when the paragraph, the contempt petition comes up, learned additional government advocate Ms.
Pramodini Kishan.
Pramodini Kishan submits that the compliance affidavit is filed, which inter alia indicates that the decision is taken rejecting the representation. In the first view, the direction is complied with, the contempt proceedings are closed and disposed of. Paragraph. It is observed that if the complainant has any grievance about the decision taken, independent recourse to the legal remedy in accordance with law is available to the complainant.
So number 19, Mr. Vachan GA.
Appearing for the complaint. My lord, they have filed the compliance affidavit, my lords. But
Complied with?
they have rejected my representation.
Same
my-
order.
My lords, let me take you to the judgment of the single judge, single. Page number 13 of my petition, complaint, my lords.
Page number 21,
13, my lords.
13.
1-3. Last paragraph, my lords. In the circumstances, we dispose of the writ petition with the direction to the respondent number 2 to decide the representation dated 10/5/2022 filed by the petitioners by keeping in mind the observations made by the division bench.
But they have not taken into account.
No, my lords.
They have taken into account in their own way.
Sorry.
They have taken into consideration in their own way. That will be part of the merit of the decision, that they have wrongly taken it. Same order as earlier passed. You file some and say that this is not in tune with the division bench order. It is ground to challenge the decision, not to continue with the contempt. Yes. Next.
Sorry, hearing on interlocutory applications, seal number 20, Mr. Chandra.
Appear for the accused number 6 and 7 in this matter, my lords. My lords, before I come to the application for direction, lords, let me take your lordships through what has transpired in this matter, my lords, regarding my compliance. My lords, your lordships will be kind enough to take order dated 24/2/2023 passed in this matter, my lords. My lords, this is a matter where they have filed a contempt seeking salary, my lords, arrears of salary. According to their calculation, the arrears of salary was more than 25 lakhs, including interest. My lords, this court by order dated 24/2/2023 has recorded their concession and the amount was crystallized at 7,24,104 rupees, my lords.
Yes.
Your lordships will find that at the foot of order dated 24/2. My lords, thereafter in my lords, there is another order of this honorable court on 24/2023. My lords, I filed my statement of objections in this matter and I contested even the amount of 7,24,104. Thereafter, my lords, this honorable court was pleased to pass this order directing me to deposit the amount in two DDs. 3,73,866 is what I admit. And thereafter 3,50,238 is contested. I've deposited the amounts in the two DDs, my lords. I've reported the compliance also on memo dated 2nd May 2023. My lords, the complainants were also given liberty to withdraw the amount of 3.73 lakhs. I'm not aware if they have withdrawn it, but I have deposited it. My lords, now your lordships will be kind enough to take the contempt petition itself.
So now what part remains?
My lords, my humble submission is I have complied with the order. I have made the deposit of the DD. Therefore, according to me, nothing remains. I've also produced the calculation. Secondly, my lords, there was an order of the learned single judge to recover this amount by way of taking coercive steps against the school if it is not paid. Therefore, my lords, the state started taking coercive action. This honorable court has protected me by the order of 20th April, directing the court not to take any coercive steps. Now, my lords, my immediate grievance before your lordships is the IA for direction I have filed. My lords, this is an aided school. Therefore, I require permission of the state in order to recruit teachers. My lords, there's a serious shortage of teachers, and when I sought for permission from the state, they say that so long as this appeal, this contempt remains pending, they cannot grant me permission for the same, my lords.
My lord, your lordship, and to increase 75 of the contempt petition. Lord, the London single judge has said, my lord, you have to pay the arrears of salary, not the basic wages. Salary includes even all the allowances also. But my lord, the respondent saying that, my lord, we are paying only basic wages. That is the dispute arising between the complainant and the respondent. Not the, what I say, my lord, the London single judge said that it is a salary to be paid, arrears of salary to be paid. Arrears of salary to be paid by
Areas of salary.
So that salary includes, my lord, the allowances also. My lord, your lordship may kindly take, my lord.
My lords, my humble submission is that has already been crystallized by order dated 24/2/2023 of your lordships, where this claim of 25 odd lakhs has now come up to only 724. Kindly see the order, my lords.
Which one?
Order dated 24/2/2023.
Lord, that is, my lord, what is?
My lords, I may be permitted to complete my submissions before my learned friend submits, my lord. Kindly see, my lords, the last paragraph of order dated 24/2/2023. I may be permitted to read it. The complainant has submitted the memo of calculation which is produced at annexure 6. It is submitted that this memo.
Where you are reading?
My lords, the very last para of order dated 24/2/2023.
At page 2.
In the daily order.
Page 2 of that order. 24 to 23.
Please, my lords, 23.
24 to 2023.
20th for 20.
Please, my lords, 24 to 2023.
20th of April 2030.
Page 2, my lord, that is. She is reading at page 2.
Ah, 24, yes.
Please, my lords, the very last paragraph of the order.
Page 2, my lord, bottom.
The complainant has submitted, your lordships are able to find. The complainant has submitted the memo of calculation which is produced at Annexure 6. It is submitted that this memo of calculation was annexed to the representation also. Though in the memo the complainant claimed the amount along with interest, it is admitted by the learned counsel for the complainant that in the appeal, the order was limited only to the payment of arrears of salary and the appellate authority has not awarded any interest. As such, the fact remains that the unpaid amount of arrears of salary as calculated by the complainant is to the tune of rupees 7,24,104. While permitting the respondent number 1 to file affidavit within 2 weeks, we direct respondent 1 to take steps simultaneously as directed by the learned single judge in order dated 17/12/2021 as per clause 2 and 3. This order has not been challenged by the complainant. Thereafter, my lords, kindly see the order dated 24/2022 passed by this honorable court. My lords, the state took coercive action against me. Therefore, my lords, I was compelled to come before this honorable court. My lords, your lordships are able to find in paragraph 9 of the reply affidavit.
Reply.
Your lordships are able to find that in paragraph 9.
9.
It is an order dated 24/2023. Your lordships are able to find my submissions in paragraph 9 of the reply affidavit. Certain statements are made along with calculation in the tabular form, where it is stated that the complainant was entitled to receive the minimum wage, basic wage, for a period of 47.5 months from 10/6/2008 to 25/6/2012, and that the aggregate of the said amount would be rupees 4,19,817. It is further stated that the complainant has received an additional amount which was paid to her mother as honorarium at the rate of 1,000 for the set period of 47.5 months, and the amount is quantified as 47,500. It is then stated in the tabular statement that the complainant would be entitled only for basic wages payable in a sum of rupees 3,71,687. Counsel for respondent 6 further submits that to show bona fides, the respondent 6 is ready to deposit 2 demand drafts in this court, one for 3,73,866 and another for 350,238, which would be in compliance with the order dated 24/2/23. In a few lines below, my lords, your lordships will see, keeping the rival contentions open for further hearing, we direct respondent 6 to deposit both demand drafts in the registry. My lords, thereafter I have deposited. My lords, if your lordships are now kind enough to see the calculation they have provided. At page 79 of the contempt petition, my lords. Your lordships will find they include basic salary, DA, HRA, special allowance, yearly increments, interest, and at page 81, the amount claimed is 25 lakhs 48,850.
We are reading which page?
My lords, at page 79 of the contempt petition. My lords, at page 79, my lords, annexure A6.
So according to you, what remains now?
My lord, according to my lord, what I have said in at page 82, my lord. Arrears of salary, increment, interest on that amount.
Wrong.
That is, how it total it comes, my lord, 25 lakhs 48,850, my lord. My lord, this is not been allowed, my lord. What has been said is, my lord, only 7 lakhs 24,000 the arrears of rent has, arrears of salary has been.
So on what basis you are asking that?
My lord, my basis at my lord, you will ask me kindly turn to page 82, my lord. The salary annual increment plus interest on the arrears of salary and interest on the arrears of salary and also the increment. Yearly interest is 7 lakhs 24,104. It comes to, my lord, 1 lakh 30,000. My lord, all it comes, my lord, with the 14 years of interest, my lord, 25 lakhs 48,850, my lord, at page 82, my lord, of my calculation. My lord, this court has said, my lord, I have entered for the arrears of salary. 7 lakh arrears of salary, my lord, your lordship, she has already read that, my lord, it was seven lakhs 24,104. My lord, that also, my lord, they are dispute saying that, my lord, not the salary, what they say is that, my lord.
Lords, my only submission is, my lords, by two different orders of this honorable court, my lords, my only submission is by two orders of this honorable court, the controversy has been narrowed down to the fact that complainant is entitled only to the minimum wage. I have taken
the
their,
minimum wage,
my
salary.
lords, I may be allowed to complete. My lords, by their own calculation, they were entitled to basic salary or minimum wage of rupees 8,825 per month. I have calculated it for the period that they have worked, which amounts to 4 lakhs 19,187. They also admit to have taken an honorarium of 47,500. I have deducted the two and come to 371,687.5. Your lordships have accepted that in two different orders. I've already deposited it. Therefore, my humble submission, my lords, is I have complied with the order. Nothing remains. Secondly, now, my lords, is my grievances with the state. Kindly see the IA that I have filed for direction, my lords, there.
But IA is
with
not
my
been
re-
submitted to me. They are not served it on me. They are not served it on me. I
This
will
one
file my
what?
objection to that.
Is posted today.
My lords, the IA has been put up, my lords. I have sent it by registered post, but I will give another copy to my learned friend.
IA1.
We have this.
My lord, may make one submission.
My lords, kindly see, my lords, my IA is not at the complainant, it's at the state. My lords, your lordships will be kind enough to take page 13 of my IA. Page 10, my lords, is an endorsement where I made a request to appoint teachers. Since I'm an aided school, I need the permission of the state. In response to that, my lords, kindly see at page 13, the endorsement issued. My lords, at page 13, my lords, of the IA. My lords, the state is saying, therefore, it is opined that the proposal shall be submitted with respect to vacancy only after disposal of the contempt petition pending before the Honorable Court, and only after necessary orders passed by the Honorable Court regarding registration recognition of the school, and also directed not to submit the proposal till then. Now, my lords, my difficulty is that I'm not able to recruit teachers, my lords.
My lord, I will file my objection to this.
My lords, this is
My lord, with
concerning the
regard to
state, my lords.
arrears
I
of
already,
salary,
my
my
lords,
lord.
I already have an order from this honorable court not to take coercive action. Kindly see order dated 24/2023. In
Correct.
spite of that order, my lords, they have taken this coercive action of not giving me permission. Kindly see, my lords, the order dated 24/2023. The last sentence.
Humble submission, Your Worship, that not to take coercive action was to, because in the appeal, there is a direction that we will recover the money. If the institution does not pay, we can even put up their assets to sale. If that is the order. Now, this is an administrative order that they cannot plead in a contempt petition here. If
My
they
lords, I've
agree to
already
the
paid the
endorsement, then
deposit.
they may go before a
I've
different
already
forum.
deposited the amount. That is why your
That is
honorable,
disputed by the
your
claimant.
lordships were pleased to give me the order not to take coercive steps. They have not taken coercive steps. I'm not making any allegation against the
With
state.
regards
My
to the
learned friend
amount.
may not say that. I'm only saying now, in view of this order, they are not allowing me recruit teachers because of the mere pendency of this contempt petition. I have already complied, my lords. I have already submitted two DDs. The amount for 3,50,000 is still deposited. The remainder, my lords, the complainant had liberty to withdraw it also.
How much amount?
Pardon?
3,73,000.
3,71,3,866 complainant was allowed to withdraw. 3,50,238 is in the name of the Registrar General. I've submitted both DDs.
Both can be allowed.
My lords, one was permitted to be withdrawn because that is the admitted amount.
Isn't it complied with?
Please, my lords, it's complied.
It is complied.
My lord, what is the dispute is that, my lord, I have only permitted to withdraw 3,73,000. My claim is, my lord, 7,24,104. My lord, this court has to determine whether it is a basic pay or it is the entire allowance.
So,
My lord, there is a dispute saying that, my lord, I am claiming a salary, arrears of salary. My lord, they are saying that, my lord, I am entitled for only basic pay, not the allowances. My lord, allowances includes, my lord, D and TA, my lord, on that basis, my lord, I calculated and I submitted before this court that, my lord, 7,24,104. My lord, they have calculated only basic pay at 8,825. But, my lord, the increment they have not calculated.
you want to file some pleading now?
My lord, any date may fix, my lord, I am ready on the argument on the main matter.
Till you want to argue? When do you want?
Any date, my lord, any date. Any date may be fixed, my lord, so that I will answer.
Tuesday?
No, whether it is the basic pay or the arrears of salary has to be determined now.
My lords,
My
may
lord,
I suggest
I have
one thing?
claimed with enhancement also, enhancement of salary, 9,950. My lord, they are only calculated at the basic pay of rupees 8,825. I am entitled for an enhancement of salary also, as per the service rules. My lord, that they have not calculated, only the basic pay at 8,825. On that basis, they are claiming that, my lord, I only entitled for the 3,73,000. That is not correct, my lord. That is the dispute between us.
My lords, with your lordships, kindly may I suggest one thing, my lords? My lords, in your lordships, it said 724,104 is the amount that is due. In that, I disputed it and I said 3.73 is the amount due. 350 remains deposited in this honorable court, my lords. My lords, I'll seek instructions on whether that amount can also be granted so that the amount of 724,104 can be given to the complainant, my lords, and the contempt may be treated as complied, my lords. I'll seek instructions on that. Since we have already deposited a DD, I'll seek instructions, my lords.
Let him also. On Tuesday?
Yes.
Next Tuesday.
Very well. My lords, may I
For
request for
fifth,
the
my lord,
interim
fifth.
order to kindly be.
Fifth. What is your good name?
Huh?
What is your good name?
My name is Narasimurthy. He is the Chandrana. He is the
Also, interim order may
Narasimurthy.
kindly be extended. The interim order may kindly be extended.
Send over to 5th of June, interim order. Extended till 6th June.
Very well. I'm deeply grateful.
Non-filing in contempt matter, still number 21. Vijay Tarnaik.
My lords, I appear for the accused. My lords, praying 2 weeks time to file the affidavit. Praying 2 weeks time to file the affidavit.
2 weeks.
Yes, my lords.
2 weeks. 11th July.
Grateful, my lords.
Still number 22.
The last occasion,
In the connected appeal.
the last occasion, the respondent number 1 has undertaken that he will comply the direction issued by the learned single judge.
That's true, my
in
lord.
vague
That's
manner.
true, my lord. My only submission is, my lord, in the earlier round of this litigation, my lord, the matter reached up to the Honorable Supreme Court, where the Honorable Supreme Court in our state appeal, Lord, has held that the case of the petitioner is covered under the Umadevi 3, and therefore the earlier directions were set aside. And in that, Lord, all these things were not brought to the notice of the learned single judge. In any event, Lord, I'm considering all those records I have collected. I need 2 weeks time to pass an order on his representation and produce the.
You will also
copy.
make kindly see annexure one submission.
8 July.
May make one submission, my lord. This complainant number 1 is attaining superannuation on 31st, my lord.
We'll
Last time
consider.
also they have taken time for compliance, my lord. Compliance.
They have
my lord.
suppressed all these things
Compliance.
before the learned single judge.
And you will also may kindly see the direction issued by the learned single judge at page number 59, my lord. Relying upon the judgment of the Honorable Supreme Court reported in 2019 4th SEC 290, wherein, my lord, the Honorable Supreme Court has held that as on the date of passing of the order by the Honorable Supreme Court in Uma Devi's case, who have completed service of 10 years, they are entitled for regularization. And these complainants have rendered service for 36 years from 1986, my lord, 86, 87, 88. And the pronouncement of the Uma Devi case is in the year 2006. As on that date, they completed 18 years of service. And the juniors to these complainants, services were regularized by the accused, my lord.
Lord,
That
those-
is also the finding recorded by the learned single judge. When the juniors of the complainants were, services were,
But he is taking time.
well,
Yeah,
any
Lord,
day,
Lord, the thing is, all these submissions are contrary to the order passed by the Honorable Supreme Court. I will produce that and I will pass necessary orders on his representation and I will produce it. And that amounts to compliance.
When shall we keep?
Lord, 2
yes,
weeks
please.
time, maybe, because I
2
have-
weeks, my lord, with the wrong time, my lord,
9th July.
9th June, my lord. 9th
Let-
June, my lord.
It's all right.
9th June.
Uh,
Who will come on 9th June?
No, no, it may be first week of June, my lord.
But they are not
Because-
entitled to any benefits
No, that is
according to the
there.
Supreme Court order.
June, they need first week, my lord.
28th June.
Great.
Number 23.
My lords, I represent complaint in this case, my lords.
I appear for accused, my lord. I pray for 2 weeks' time to file my repayment.
2 weeks. Who appears?
I am for accused, my lord.
Complained with or not?
I represent complaint, my lords, in this case.
Yesterday I filed wakalat, my lord.
This is which order you under? Page 21.
No, this is, my lord, the suit for specific performance was decreed in favor of the complainant by the first appellate court, my lord.
For 2 weeks. It will be
Much obliged, my lords.
10th July, 11th July.
Number 24. So Sri Ramakrishnan, party in person.
Lord, in 24.1, the appeal, my lord. I am for the appellant. My lord, on the last occasion, Lordships heard the matter, my lord, and then granted an interim order of stay. My lord, the matter has to be heard on merits and disposed of. I have also served a copy on the party in person, my lord. I'm also ready with the synopsis and citations, my lord, if your lordship permits. I can.
So he is number 4.
Sorry, my lord.
He is number 4. Assistant manager.
Yes, please. Order dated 23/4/2024, your lordship kindly see, my lord, in the appeal. 24.1,
Your appeal.
my appeal, bank's appeal. My lord, the learned single judge, my lord, directs grant of promotion with retrospective effect.
order dated 23/4/2024. Delay was condoned, my lord, and para two, your lordships have noticed that having noticed that in the order dated 13/10/23 passed by the 11th single judge, impugned in this writ appeal, 11th single judge has been allowing the petition straight.
My lord, on 23/4/2024, the learned advocate, he said that the learned single judge has straightaway passed the order, directed the appellants to grant promotion that to 1/4/2013.
Court cannot direct the granting of promotion straight away.
He said, straightaway he said that is accepted.
That was the last time.
But that the learned single judge has not straightaway
Your-
ordered, my lord.
Your case can be considered at least.
No, yes, my lord.
That
but-
again is not permissible, my
My
lord,
lord.
in law. I would
My lord,
demonstrate that, my lord.
let my present my,
My
for
lord,
2 minutes, my lord. And that day, my lord, they have hidden the affidavit filed by the appellant number 3 in the learned single judge order. That I produced in statement of objections. That you can see, my lord.
Which one?
Statement of objections, I have served it, my lord. I have marked annexer R1 there.
But you are.
It is not,
You are appearing in appeal.
14%, my lord. In statement of objection, already I filed it. I marked annexer R1 also. They accepted, my lord.
In view of the interim order, contempt will not survive.
Contempt will not survive.
We fixed the main appeal. It you already noticed.
Yes, my lord. Letter and argument also I submit, I'll submit, my lord.
So order in appeal. This writ appeal, this writ appeal was listed on 23/4/24. Since copy of the appeal was not forwarded to the party in person, same was adjourned. Mr. Third learned advocate, Mr. Pradeep Sarkar Saukar, assisted by learned so and so the appellant. And learned party in person, Mr. G. Ramakrishna, appearing on caveat for the very reasons recorded in order dated 23/4/24. More particularly that the directions contained in the impugned order passed by the single judge is to grant promotion to the respondent.
With effect from 1/4/2013.
Straightway would not have been ordered by the court. The court would at the best provide for considering the case of the employee for promotion. The appeal deserves final consideration. It is admitted. The same shall be posted for final hearing after in the week beginning from October, in the first week of October 2024. The interim review already operating in respect of stay of the directions contained in paragraph 40 of the impugned judgment and order will operate, and that the directions in the said paragraph 40 of the impugned judgment shall remain stayed during the pendency of the during the pendency of the appeal, to be subject to the final outcome of the appeal. Full stop. Then contempt. The writ appeal number 134 of 2024, which arose, which has been arising from the judgment and order brought under the contempt petition, has been acted by order given date by this court, and the stay is granted. Stay granted has been confirmed, staying the directions in paragraph 14 of the impugned judgment. In that view, the present contempt petition does not survive.
Yes.
For the present, the party shall stand bound by the final outcome of the appeal.
Just have disposed of the contempt petition. As not-
Contempt is disposed.
Very well.
November first week.
Very well.
Firstly, submission. Date, madam. Date.
November first week.
Taping.
You want date? All right. 11th, 5th November.
5th November. Very well.
Serial number 29, my lord. Afternoon, I have some personal inconvenience and for first respondent in the matter. We seek for a adjournment, my lord, in this matter. But he is continuously
All right,
absent.
when
No, sir, I'm
we'll take
available,
up
sir. I'm available, sir.
19th June.
Sir, I'm available, sir. I can talk. to you. I'm available.
He is a party in person in this.
Party in person.
You are available. We are also.
Okay.
Serial number 52.
19.
Lord, may I make one out of turn submission?
Yes.
Lord, one matter, the Lordship reserved it, Lord, sitting with His Lordship Justice Krishna Dikshit. Lord, this matter was reserved on 12/3/2024. This one development, one
It will come.
Rajasthan judgment has come. If your Lordship permits me, I'll pass it on to your Lordship.
Normally, it is not the right thing to.
I have informed the other side.
You come with the other side.
We have in fact taken acknowledgement also. We have given the copy also to the other side. And in fact, we are mentioning today also has been,
In Gujarat, similar thing had happened once. I'm told, I'm not witness to it. That after the judgment was reserved, somebody gave the judgments or notes. And that issue went up to Supreme. So normally it is out of propriety that once the judgment is reserved, you can give.
not eventually
All
that may
good-
have to happen.
All good thoughts are welcome. So all good judgments are also welcome, so that we can decide it. But you
Lord,
come-
in fact, your Lordships reserved it on 12th of March and the judgment has come on 25/4. Lord,
Forget about Rajasthan judge. To utilize an appeal if so required, or other side will do, we don't know.
I've informed, if your Lordship permits me, I'll pass it on, otherwise, Lord.
All right.
Oblige me.
Seal number 2, Mr. Eugene Prabhu Bharat. Seal number 2,
Who is nobody? None was present. None was present on behalf of the contempt petitioner. In the first session, when the petition was called out, he stopped. It was called out again in the second half, soon after recess. Nobody appeared in the second call also. The petition could have been dismissed for want of prosecution. However, in the interest of justice, extend over to next Monday, 3rd.
seal number 66. Mr. S. Venkatesh Prasad.
Yes, what is it?
To the main road. This road leads to landlocked villages. A lot of the last date of hearing, a lot. Resolve this issue so that road will not widen. Because cannot get through to the village. At the end of the road. He's my lord. He has filed. The Lord takes them out. Junction.
That too with only
Petition number
RTC.
13.
Yes.
Yes,
Respond number 13.
Yes.
basing on RTC, injection is granted, my lord, on the public road.
You file appeal then. What can we?
Kindly, page number 105, my lord. Kindly, please verify. In that, one public school, elementary small children, 105, my lord. 105. small elementary school is grabbed by the 13th respondent, or one public borewell also grabbed by the 13th respondent. Public road, the public elementary school, and this public borewell, all three are in the wrongful custody of that 13th respondent, my lord. It is hence it is come, hence this bill is comes under Karnataka High Court rules, bill rules 7 subclass 4 and 5, my lord. Torture of villagers, co-villagers, and bad roads causing accidents and causing inconvenience. And not only that, my lord, this bill also comes resemblance with
What shall we do, miss? Without notice, to the best of your capacity, you do. In fact, we are not inclined to issue notice. This is an encroachment. What is it? It's not an encroachment. They want mud road to be developed as regular. Widen.
But the land has to be acquired for the right to the road. That will take some time.
So we have taken a view, not only we, also Supreme Court. These are the executive functions, making of road and widening of road and laying down the road. So this is only because some serious public inconvenience is noticed, we ask you to take it. She will try to waste.
Please, my lord.
Very in earnest manner.
Another humble submission is I myself visited 7 times. That is poor quality of public is very poor. I myself visited 7 times. I made 2 hours classes, legal education classes. I also done to the common public by grouping them. I myself visited. I saw the very poor quality. Kindly on with folded hands, I am submitting. Kindly on humanitarian grounds as early as possible resolve the matter.
So she will earnest.
Please, please.
And you say obliged to her, not to the court.
Please.
You need no. You need notice. The prayer in this public interest petition is to direct the respondent state authorities to develop the East Bend Republic Mud Road with 12 feet width, having 1.5 kilometer length, which is stated to be running through the agricultural lands between the villages The public interest petitioner has pleaded that the condition of mud road is too bad to be properly utilized by the commuters and the villagers. It is the prayer to make the road fit and motorable with develop by providing on the road the facilities of lighting and other facilities for the vehicular and pedestrian traffic. While the court is aware, paragraph, that laying down or developing the road is essentially a public function, executive function, where the court would not interject itself. Since it was demonstrated that the condition road is affecting adverse the large segment of public, and further in view that learned additional government advocate Srimati Neelofar Akbar has fairly agreed to take instruction to be amicus to the cause from a notice written on 11th July.
One humble submission, my lord.
Notice shall go to respondent 1 to 11 only. 1 to 10, 1 to 10. On who? 1 to 7. 1 to 7, 9 and 11, and 9 and 12. For the rest of the respondents, notice is dispensed.
Notice will have to go to respondents 8, 13, 14 and 15.
What about 1 to, you're accepting?
I accept for respondents 1 to 7.
1 to 7, accept. Notice shall go to number 8.
Notice should go to respondent number 8, 13, 14 and
8, 13, 14 and 15. Notice to 11 and respond 11 stands will be are dispensed.
One humble submission, my lord. Tahsildar is present in the honorable court. Kindly make arrangements, kindly do the make arrangements for emergency movements, if any. Please. For emergency movement, my lord. It is humble because poor people will be suffered, my lord.
See on that.
Please ask them. If now is the road is there, make arrangements that he will whatever possible emergency movements, pregnant women, whatever moment. Please, people could not be suffered, my lord.
Who will be the competent authority to? So let us you take it.
Consider the matter. I am praying. Consider the matter for emergency movement of pregnant women, the senior citizens, any heart attacks, even snake bites, and because forest is very near, snake bites, scorpion bites are happening.
On next
Please.
day. On next day.
And please. Oblige.
25 Nishant
Appear for
Levy.
the complainant.
Appear for the case.
Appear for the complainant. 2 weeks time. 2 weeks time, why? Long journey. What is it about?
Yes. So which are the directions which are breached?
My lords, the directions, my lords, are at page number 160, my lords. 160.
160.
The operative portion of the order, my lords, commences at page 158.
Yes.
The direction, my lords, H at page 160, H, J are violated. This is a matter, my lords, petitioner is a BBMP contractor. The contract, my lords, was in the pre-GST regime. The difference in tax, my lords, has to be paid by the BBMP, my lords, to the contractor. We'll have to calculate it. We have furnished our representation and the calculation.
My lords, we have also made several representations asking them to give us the detailed calculations invoices, my lords, so that we can calculate the GST amount. And also they have sent us a legal notice invoking arbitration, my lords. So I have to look at the correspondence. So 2 weeks time may be given, my lords, to file an affidavit.
At the request of learned advocate Mr. So the respondent stand over to 8th July. It's a 3rd July. 3rd July. 3rd.
The next matter is
26.
also similar.
Similar matter, my lords.
26 same order.
Grateful. Grateful, my lords.
Number 27. Mr. Yeshu Baba Mishra.
For the complainant. The accused was directed to hand over on previous date of occasion. The DD has been handed over to the complainant, my lord, in part compliance of the order. 50 lakhs has been handed over. This has to state by when they will make the remaining payment. my lord.
30 lakhs. This is that matter.
Please, maintenance matter.
So what is the last order?
Please.
The professor.
Please, please.
You filed the affidavit?
No, fifth, I will pay the 30 lakhs, my lord. Fifth, 5, 6, they have given date. And on that day, we will pay the 30 lakhs amount.
Further 30 lakhs.
Further 30 lakhs.
Please.
But the last order required you to file affidavit. On which date affidavit shall be filed with respondent response specifying the date of making payment of the rest of the amount.
Yes, ma'am.
So now what remains? 30 lakhs.
30 lakhs.
30 lakhs
We
has
have
been
paid 30
furnished.
lakhs.
The
Another 30 lakhs going to pay in the 5th of June.
My lords, the total amount is 75 lakhs and 30 lakhs has been paid till date.
30 is paid.
30 is
Further 30.
We'll
the
go to
council
give.
shall be
Yes,
paid.
next week we'll give.
So let us see.
Please.
When shall we keep?
5th.
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 To file affidavit on that.
Yes, sir,
Why you are not?
I'm not brought to the partition outside. That's why I'm undertake that. 50 will definitely be going to pay.
Learned advocate, Mr. So-and-so, respondent. Stated. Response to the order passed on 18/4/24, more particularly in the context of what is observed in paragraph 7 of the said order, that the respondent shall pay amount of rupees, further amount of rupees 30 lakhs.
Yes.
On or before
on or before 5th of,
5th of June.
5th, definitely. will be.
5th of June. Full stop. Any of the statements from which for the present state satisfies the counsel for the complainant from a stand over to 6th.
Yes,
6th.
6th,
6th or 5th?
5th, 5th,
5th. But no, matter to be kept or no.
for only same day,
Same
5th
day.
itself.
This is number 28. It is Smita RB.
My lords, in this matter, I appear for the respondent, my lords. My lords, I've duly complied with the order of this honorable court, my lords. I'm placing the compliance affidavit today, my lords. My colleague is present in the court, my lords.
I
Then
have
why?
one submission to make.
So leave it to your colleague. You are there. You are there on behalf of the, yes, it is complied with.
Yes, ma'am. Filing the
Pass
complaint.
it. So what was the direction?
Your lordships may turn to page 26. The learned single judge's
Refunded.
order at.
Amount to be refunded.
Yes, my lords. One submission on the interest part of it, if your lordships may turn to 26, page 26, the direction is at 2. At page 26, the second direction, the amount in deposit made by the petitioner subsequent to the interim order dated so-and-so is directed to be refunded to the petitioner. It shall be refunded by respondent number 1 within a period of 8 weeks, along with interest at 6% per annum till the date of payment. Lords, the amount was deposited on 9/4/2019.
So delayed by,
Sorry, my lords.
delayed by what period?
It's about 5 years since then. The payment has been made on 23/5/2024.
So it is paid with interest or not?
Seems like 1 year's interest has been paid. The total amount that has been credited is
Sorry.
about 29 odd lakhs.
My lords, I need to
My lords, if I may make one submission, my lords, in this regard, my lords.
Yes.
My lords, the respondent herein, that is the accused for whom I'm appearing, my lords, he is the chief executive officer of Doddatoguru Zilla Panchayat, my lords. There was an accreditation which took place last year, my lords. There was an administrative disarray which happened where the roles and responsibilities from Gram Panchayat was handed over to the Zilla Panchayat, that is to me, my lords. My lords, this delay is not deliberate in my humble, is my humble submission, my lords. And I would apologize in this regard, my lords.
What your senior is saying?
My lords, my senior has mentioned that the delay is not intentional. So for anything further,
It is right, but then there is an direction by the learner single judge. We can't modify in contempt jurisdiction. Are you satisfied without it?
My lords, my instructions are to seek interest. Because 5 years, the payment was made in 2019.
Only thing that we can modify in contempt jurisdiction. If it was a great jurisdiction, we could have said that. Take instruction.
please, I'll take instruction.
The affidavit of compliance filed today. So that the amount of refund as directed by learner single judge has been paid to the complainant. However, paragraph learner the complainant stated that the direction of learner single judge is to pay the amount with interest at the rate of 8%. 6%. And that the full interest is not paid. Full stop. In response to this, learned advocate Miss Unit. So and so stated that non-payment of interest is not intentional. However, she wants to take instruction. What is the amount of interest?
Notes if the interest is computed, what is still payable is about 6.78 lakhs.
6.7 lakhs.
Yes.
And what was the amount to be refunded?
Amount that was to be, the total amount that has been refunded as of today is 29 lakhs 3,472. The balance that is still payable, that is the interest component, is about 6.78 lakhs.
So
So
you are a-
totally the amount that should have been paid was about 35 odd lakhs, 35.82, out of which 27 has been.
You are a panch, they are a panchayat.
Yes.
You are panchayat.
Please. No,
Work out something if possible.
I will seek instructions, Manoj. Please, Manoj, I'll seek-
Say
I will seek
some part of the interest and rest they will forgo.
Very well, Manoj. I will see.
Otherwise, interest will go on mounting.
Yes.
When shall we keep? 2 weeks. 1st July.
So 29, 30 are urgent. Seal number 31.
Grateful minutes.
Bhargavi Dev.
It's appear for respond number 5 and 6 in this matter, my lords.
It's a case of encroachment of a stormwater drain as well as a road. So far as this village is concerned, my lord, this is a public interest litigation filed by the villagers. Lord, we kindly page 87, which is a sketch prepared by the Assistant Director of Land Records, which demonstrates that, page 87 is the translated version of the sketch, which demonstrates an encroachment by the respondent numbers 6 and 7.
Lords, may I just
I'll reply.
Lords, I have filed my wakalat. Lords, I just want to bring one aspect for my lord's consideration. I'll file a detailed reply, my lords. I bow down.
You are encroaching.
No, my lords, I have not encroached. My lords, there are several proceedings, criminal proceedings, revenue proceedings pending in this matter. My lords, the first petitioner and the respond number 5, my lords, are political rivals, my lords, at the panchayat level. The 5th respondent, my lords, is a successful candidate, was a member of the panchayat. The first petitioner did not survive. My lords, there's a criminal proceeding initiated by the 5th respondent against the first petitioner. My lords, a more glaring fact. Lords may kindly see there's a mandatory declaration, my lords, that must be filed as per the PIL rules, my lords. It's very stringent. It's not like a normal writ, my lords. My lords, I take serious exception, my lords, to the first court being made an avenue for settlement of, personal scores, my lords. My lords, the first court, the petitioner making the first court, my lords, in the PIL jurisdiction.
Every court is court.
My lords, what has happened? My lords, what happens, my lords, is PIL, my lords, is for real public interest. I bow down, my lords.
What do you mean by first court is being made?
My lords, when the pendings, I'm sorry, my lords. I'm sorry. My lords.
Court is court. Every matter is every matter.
No, my lords. PIL, my lords.
Don't any color and comment to any matter.
I bow down.
Any argument.
I'm sorry, my lords.
Be straight in making your submission.
I'm sorry, my lords. I entirely bow down, my lords. What I'm trying to say, my lords, may kindly see page
No colored
28.
arguments before the
I'm sorry, my lords. I completely bow down. That was never my intention,
You
my
have
lords. Lords, PIL rules.
You have to.
I'm sorry. I'm completely apologetic, my lords. But my lords, my only difficulty is this. Nowhere, my lords, in the writ petition, they have mentioned that all the petitioners are family members. The first petitioner, the first petitioner's brother, the first petitioner's aunt, the first petitioner's uncle, all of them, my lords, have, my lords, collectively come hammer and tongs, my lords, against the respond number 5.
I'll your reply.
I'll do so, my lords. I'm sorry. I reiterate, my lords, it was never my intention. My lords,
That is over now.
I'm obliged, my lords.
My lord, that part. My lord, at the end, there's no response
Sir,
insofar
why
as
you are
the,
reminding yourself? Yes, I'll reply. You also file reply.
my lord, because my application for restraining them from construct, because they're constructing, notwithstanding all of these allegations which are by some political.
In course of the hearing today, learned the additional advocate Ms. Nilofer Akbar stated that the notices under the competent law, under the law is issued to the alleged encroacher. Full stop. She wants time to file statement of reply. So also wants learned advocate Miss Mr.
Vinay Venugopal, my lords.
So and so appearing for this concourse to requesting the court to permit him to file reply. Both the respondents may file reply before the next day, put upon 1st of July. 1st of July.
Obliged, my lords. I'll file. 5 and 6.
Number 32. Vasant Madhav, yes.
Number 3.
Lord, my submission, my lord. Shri D.R. Ravishankar, senior advocate, was representing the appellants. He is not well with sore throat. He sought accommodation for weeks, next Monday or Tuesday, my lord. And
Very good.
this,
So land was acquired. For park, your land.
I'm the KADB, my lord, in Karnataka Industrial Area Development Board.
You acquired.
I acquired it.
They won't time.
Your lordship said.
he
My
has
lords.
some health issues. Next Monday or Tuesday, I sought, my lord, such accommodation.
My lords, I beg to appear for the third respondent.
It can go to 26th June.
Any day.
My lords, can I make a request, my lords? I appear for the third respondent.
Yes.
My lords, in fact, we have paid the entire consideration. There's an interim order. Because of that, my lords, we are being prejudiced. I understand my learned friend is not well. If it can be.
Maintain status quo.
Yes, my lords, there's an order to
This
maintain.
matter, my lord, it was not granted at the earliest, at the initial stage, my lord. After hearing the parties, an interim order was granted.
We are not a party at that point, my lords. We have been impleaded subsequently.
Interim order granted on 13/6/20.
Yes, ma'am. Subsequently, after hearing the parties.
No, we are not heard, my lords. We have been impleaded on 25/1/2024.
Who are you?
Well, the land has been allotted to us. We have paid the entire consideration. Thereafter, my lords.
Developer.
No, my lords.
My lord, what happened was he was required to pay, my lord, 17.5 crores. He did not pay a penny. Then, my lord, he files a writ petition after 2 years. That was
10 years.
While
10 years.
He was, my lord, the.
My lands were acquired, my lord.
His lands were acquired. Thereafter, my lord, that land, my lord, we developed it. Then, my lord, he wanted some alternative. We agreed to give him some alternative land. But he was to give, my lord, the development charge, all that. 17.5 crores, 2 years he did not pay. Ultimately, my lord, 5 years.
10 years, 10 years.
10 years, I stand corrected. Ultimately, my lord, the learned single judge dismissed it. They have now filed an appeal against that order. In the meanwhile, my lord, we have allotted it to the third respondent, fourth respondent. They have paid the entire amount, consideration of 17.5 crores.
25 crores.
Various issues that are involved, my lord, it was argued at length before all the benches. All I request is a week's accommodation because the senior is not well. That's my submission, my lord.
No urgency. No, there is an urgency because interim order is over.
Interim order till
26th of June.
Yes.
Can I request it for 28th, my lords, instead of 26th?
28th of June, no different.
Please.
Much.
Grateful to your lordships.
In order operating, already operating, will continue till the next.
Number 33. Manmohan PN.
For the curator respondent.
My lord, in this, can I seek one accommodation, my lord? I'm in the midst of a parted matter. So can I seek one accommodation if it is not inconvenient to my learned friend?
But the department is closed.
Department is closed now, my lords, as professors. My lords, I had to obtain loan after taking their consent.
Who is for the professor?
I am for the professor. Now, my lords, I am in a lurch where I don't have a penny. And my lords, my loan, which I have a house and children, 52, my lord, nobody will give me a job today. They have accommodated other professors in this department to other departments. Anyway, my lords, some other, but shortest accommodation, because my lords, my problem is the bank now wants to take up recovery proceedings to take up my house also. They gave me no objection to take a loan. Because of that, I have taken a housing loan, put up a house. Now I am virtually.
This is all just, the professor is the employee of the university?
No, of the college, my lords. I was my lords, I've been working
Professor
for
is not the employee of the department. He is the employee of college.
college.
No,
I'm
he was inducted, my lord, to the department.
I was
That
inducted to
department
the
was closed
department.
Because,
So that is the bone of contention.
yes, 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 that's the issue, my lord. Because he is specialized in that particular subject.
We'll consider.
Anyway,
Some shortest. of-
When shall we?
whenever subject, your lord, I'm sorry, my lord, I
First.
had to.
First,
Please.
first July.
Lords earlier than,
Early.
because my lords, there is a little, because his children are also, my lords, facing problems for fees.
24th June.
Lords, and also there was an understanding, the single judge, before the single judge, they will not press. Last time they had.
Single judge, what is going on?
Lords, there are two more matters before the learned single judge where they are stay operating. They want to, before the vacation, they said that they will, that was the understanding when this matter was adjourned prior to vacation. That they will not move that. Because,
All right, whatever, my lord, has happened, we'll continue with that. If we have given an undertaking. No undertaking.
it was, my lords,
Court
well,
mentioned, court informed us till the next day, still today, don't precipitate the matter. We have not done it before the land single.
so if this goes.
Whatever my lord says.
Are they connected?
No, they're not
Yes,
connected.
in the sense,
They're not
same, almost the same issue. Because of the interim stay, they wanted to move, they have filed application there, that's
So
all.
this is an appeal there. This is initial.
But anyway, if they don't, 24th, your lordship may have it, my lord.
Today is what? Today is,
Today
It's 29.
29th,
little earlier you can.
All right,
please,
subject, your lord.
10th June.
please.
Please.
Great.
Interim order.
Interim order to be continued.
Interim orders will come.
Please, great.
34 also.
Yes,
34 also.
33 and 34.
35 adjourned. See number 36.
Lord, I beg to appeal for the complaint.
Your lordship, apologies, your lordship.
36. 35. 35 will not. It will go before different court because my brother is the author of the judgment.
See number 36. Mr. Sivacharan R.
My lords, I beg to appeal for the complainant. My lords, plea, my lords, was recorded on the 13th of April 2023.
So what is the content?
My lord, may I make submission, my lord. As the order passed by the learned single judge actually is, it is under challenge in the writ appeal, the connected writ appeal. And whereas they are the complainants, they are the retired teachers. They were working under the accused, that is respondent number 1 and 2 institution. And they retired in 2004 and 5. And after retirement, what they did was they filed application before the institution and also made representation to the government saying that we should have been paid the government scale. That is their claim. And because it is an unaided institution, I appear for the respondent number 1 and 2, that institution. And because we are not in a position to consider that one because it is the unaided institution. Subsequently, they filed writ petition before this honorable court. And in that writ petition was specifically the learned single judge has passed the order and it was rejected against us. Actually, that claim was, that is, I have produced along with the, in the writ appeal, my lord. And subsequently, yet again, they filed the writ petition In that writ petition, we said, appeared before the learned single judge, whatever payable to them will be paid. That is we will pay the amount. That is the only retirement benefit. And so far as the difference of salary, we are not liable to pay. Therefore, we filed the, after receipt of the, my lord, after receipt of the notice, and
Order is at page 10. This is the order.
please, at page number 10, I will take your lordship back.
So what is contempt? Placing undertaking on record. Where is the undertaking? What undertaking was
My
given?
lord, it was an oral undertaking which was rendered.
No, my lord, undertaking that whatever I am liable to pay, that I will pay.
Where is
That,
it? Where is that undertaking?
based on that, my lord,
Where is that undertaking?
But may I make a submission, one submission?
please, my lord. That
May
is, I have filed a reply, my lord, to this contempt petition. I have filed the reply, and therein I have stated that whatever I am liable to pay, that I will pay. It does not mean that which they are not entitled. That is, they can claim it before the government, not against us. Because in the earlier round of that writ petition, order was suppressed before the learned single judge. Therefore, after,
Due to the teachers will be paid.
please, my lord. Therefore, my lord, after receipt of this notice from the contempt, in the contempt notice, we have filed, that is, the institution has filed the writ appeal.
Respondent. You are for respondent.
Please, ma'am. I have filed the connected writ appeal, my lord. In that, I have challenged, because I filed, even I filed the review petition before the learned single judge, saying that because the whatever even earlier round of litigation, that was not brought before the notice of the learned single judge.
But why you are arguing? Where is the counsel for the?
My lords, I appear for the complaint.
You are there, Acha.
Yes. My lords, what
So
my,
you have to- So whether counsel's statement on instructions and breach thereof amounts to contempt or not, you address on that.
yes, my lords, may I request my lords to kindly turn to page 5, my lords, of the contempt petition, para 9.
These are the dues for.
Yes, this, my lords, yes, this was the quantification, my lords, which was done in the writ petition itself. My lords, based on a dictum of this honorable court, my lords, in the case of S.S. Anand and others versus management of Mahatma Gandhi Vidyapeeth, which my lords would find reference at para 3, page 4. My lords, while this quantification was on record, the learned counsel for the accused institution, my lords, undertook that dues in terms of this calculation would be paid. The undertaking, my lords, is recorded, my lords, at page 11, my lords, running page 11, page 2, my lords, of the order passed by the learned single judge. My lords, sir. It says, learned counsel for the third respondent on instruction submits that the amount due to the teachers shall be paid within a period of 4 weeks from today. My lords, this was the undertaking given. My lords, this was not complied with. I would say, my lords, it was complied with partially. My lords, which necessitated us, my lords, to initiate this proceeding. And my lords, the accused, my lords, who appeared, charges were framed. And my lords, his plea was recorded on 13th of April 2023. If my lords were to be kind enough to peruse the order sheet, his plea has already been recorded where he has pleaded guilty. Would my lords be kind enough
Please,
to
my
peruse
lord.
the order sheet?
Kindly see my lord.
Where is your appeal?
that is a writ appeal number 217 of 2024, my.
What is the ground?
My lord, in the earlier round, that is, they filed the writ petition before the Samla court, and I may take your lordship to page number 24. That is the order passed by at the first point of time, they claim only against the government. And though we are the formal parties, whereas the learned single judge has passed the order. Kindly turn to page number 26, para number 3, my lord, 2 onwards. The petitioners have sought for a writ of mandamus or any other appropriate writ or to direct the first respondent to consider and dispose of their claims for terminal benefits and also for a direction to the respondent number 3 and 4. That is very important, my lord, to issue retirement relief letter in favor of the petitioner. Then obviously the writ again as against the respondent number 3 and 4, that is, I am the respondent number 3 and 4 in that writ petition. We are the appellants. Not maintainable in as much as both of them are unaided private institutions. Hence, the main relief which is sought for seeking a direction to respondent number 3 and 4 to pay the terminal benefits cannot be granted. But however, what is significant is that both the petitions have given representations dated so and so, a copy of which is produced at annexure so and so regarding non-settlement of retirement benefits, and the representation given by them to the institutions at to respondent number 3 and 4 have not been replied. Indeed, insofar as this aspect is concerned, it is to be noticed that under section 133 of Karnataka Education Act 1983, the government is empowered to give certain directions. Under section 133(2) of the Act, the state government also may issue such direction to the education institution or tutorial institution as in its opinion are necessary or expedient for carrying out the purposes of the Act and to give effect to any of the provisions contained therein. Having regard to the fact that the representation is given to the petition by the petitions in both the petitions to the respondent number 1 for settlement of terminal benefits. That is, the respondent number 1 is the government. So far as the differential amount is concerned, it is the government is to consider, not myself, my lord. The institution is, because it is specifically held in the earlier round of the writ petition, in this writ petition, that such a claim is not maintainable against me in para number 3.
So
And so far as the terminal benefits, my lord, I have paid. Please.
how many teachers are there?
There are 2 teachers.
How many?
Here only 2, my lord. The challenge, but there are others have also claiming the same.
What amount you are supposed to pay under the order?
They are claiming more than 4 lakhs, I think, my lord.
4 lakhs.
Oh, yes.
What is that? 1,06,000.
That we have already paid, my lord. Even it is admitted by them. We have paid.
Review is reject.
Review rejected. Therefore, my lord, I have preferred.
Your review.
I filed review petition before the learned single judge, my lord, and that is rejected. And therefore, I filed a writ appeal because there is a delay for this reason, my lord. Because we received this contempt notice was filed in 2020. We received the notice in 2023. Notice was issued to us. That was complied. There is a delay again. There is more than 1 year in filing the contempt petition also. Therefore, on that ground also it is.
But they worked as teacher or not?
I worked as whatever, my lord. My submission is this, my lord. Their claim, so far as the differential amount, that is the government scale, we are not liable to pay. Even in the earlier round of litigation, even the learned single judge has held that we are not liable to pay. And because we are an unaided institution, we are liable to whatever we are liable to pay, that we have paid. And even also retirement benefit, that is the gratuity was already paid. Now they claim the differential amount, that is the government scale, that we are not liable to pay because we are the unaided institution. That I explained, man.
In appeal.
My lord, the reason is this big. Subsequently, my lord, after what happened was, after the disposal of the writ petition, we have made the payment. They filed contempt in 2020. Payment was made immediately after the disposal of the writ petition. And subsequently in 2020, they filed the contempt. And notice was issued in 2023 to the respondents. Immediately thereafter, we filed this appeal, my lord. Therefore, there is a delay in filing the appeal. Therefore, 1,000 days delay. We actually, on the bona fide reason, actually we have made submission before the learned single judge that whatever liable to pay, that will be paid. It does not mean that the differential amount, because it is not the aided institution. Even earlier round also, what I have read, my lord, it is very clear in the order. The writ petition was not maintainable against respondent number 3 and 4. What is the order passed by this learned single judge at in annexure A, para number 3, my lord.
What is page 13? Page 13. So where you made a statement. Learned counsel for the third respondent when instruction submits that the amount due to the teachers shall be paid within 2 weeks from today. What is this?
Please, in view of the above, the writ petition stand, that is the order passed in the writ petition order was culled out by the learned single judge. My lord, this portion is extracted. The order passed in the impugned order, page number 11, my lord, that portion was extracted in the review petition.
Same order is quoted.
Please, my lord, that is extracted.
You deposit the amount.
My lord, my submission is this, my lord.
It is not that higher amount. You can deposit 3 lakhs and 4 lakhs. You are at school, minorities,
Please, my lord.
whatever it is. You are at
No,
school.
there are several employees, my lord. In the meantime, in the amount is paid, and all the retired employees will make a claim against the institution. We are unable to run the institution. That is a financial burden because of the financial burden, my lord. Even several of the already retired teachers, any of these, my lord, order, and they are making claim against us.
The order and brought under this, the order brought under the contempt jurisdiction requires respondent 3 school to pay the amount due to the teachers. As per the submission made by learned for the state respondent. The payable amount to the teacher is supposed to be paid within a period of 4 weeks. No plausible explanation has been forthcoming. as to why he said amount should not be paid to the teachers. More particularly when it is an unequivocal direction by the court subjected to contempt jurisdiction. Respond number 3 is directed to place on record the calculation of the amount payable to both the teachers pursuant to the order. Also, such calculations will be placed on record on affidavit before the next day, put up on 2nd July.
I'm so grateful.
Then be ready for deposit.
So grateful.
Number 37 urgent, number 38. Neil Bruce.
Your Lordship, the Tahsildar has aggravated contempt at 2 counts this time. They mentioned that they do not have my address in one endorsement, and then on the same address, they've also sent a letter why they cannot issue a EWS certificate. The learned single judge had ordered it to be given within 1 week.
Your party in person.
Yes, Your Lordship. And that too, they have not mentioned the father's name or the mother's name properly. And I specifically request in the affidavit not to mention father's name, as he has not been part of my life since my birth. He has abandoned me and my mother at birth, so I never put his name in any record. And the same is supported by ABC versus State of Delhi in Honorable Supreme Court, Your Lordship. This writ petition was allowed on 18th April of 23, Your Lordship. Sir, may I produce the endorsement of the Tahsildar?
It is not produced.
No, Your Lordship. This is after the contempt was filed. This has not yet been produced in this court.
So what is the relevance of this?
Relevance is they mentioned they don't have my address in one endorsement, and in another endorsement, this is in this endorsement, they've sent it to the same exact address. Translated copies on the second page, Your Lordship. It reads as follows. You have submitted an application for issue of Brahmin caste EWS certificate, and in view of non-submission of the prescribed documents, you, the RI and the village administrative officer have reported to dispose your application. And in this office, the said certificate is approved. Your Lordship, I would like to point out that the EWS is not for Brahmin. It is for anyone in the general category. But the revenue department is treating the EWS as only for Brahmin category. And they have asked multiple times for a caste certificate to be provided. This learned single judge has dispensed off with that requirement completely, Your Lordship. Because I studied in Air Force school, over there they do not recognize any religion. Because of that, they are not ready to endorse and give any sort of caste certificate as well. And they mentioned the Tahsildar and the revenue inspector, the spot inspection report is obtained and verified. Whereas the Tahsildar, revenue inspector, or none of the officers of the Tahsildar's office have visited me or asked for any documents. And there's an office objection regarding the respondent 3. Your Lordship.
Why they are not issuing certificate?
Caste is the main reason they're mentioning.
No, that you're thinking.
Not my saying, Your Lordship. Over here, they mentioned it in the
Nothing
endorsement.
is reflected on those score on that count in the direction is the mandamus issued to number 4, respond number 4, Tahsildar to issue corrected. What is corrected? EWS certificate to petitioner. What is corrected?
They have mentioned my mother's name as Reshmi M and my father's
They will
name.
correct and do it.
Whereas my father's name should have not been included in the first place, Your Lordship.
That we do not know nothing about. No. You don't want your father's name.
No, Your Lordship.
File a separate petition.
And that too, this was in support with the ABC versus State of New Delhi in the Supreme Court.
Maybe
Your
this is
Lordship.
contempt jurisdiction, Mr. Don't mix up.
But Your Lordship, both parents are not there. Father abandoned at birth and mother passed away in 2021. So I do not have any income as such.
That is not entitled to, then at least take that instead. But there is or then file an appeal, but mandamus is issued due to obey. Of whatever kind certificate you issue. Mandamus issued to 4th respondent, Tahsildar to issue corrected EWS certificate to the petitioner.
And because the respondent 4 was not responding to this orders, I have approached the respondent number 3, the deputy commissioner as well, Your Lordship. The deputy commissioner directed the Tahsildar, but Tahsildar has not done anything.
About the direction of learned single judge that respondent number 4, Tahsildar shall issue corrected EWS certificate to the petitioner within 1 week.
The urgency of this EWS certificate now is, Your Lordship, that NLSIU is asking for the certificate on 28th of June.
Notice is issued.
Your Lordship, a last date notice was issued.
So you are supposed to issue corrected caste.
Yes.
With mother's name.
So the caste certificate is always issued in the name of the father.
But name of the
That is also held by the apex court, Your Lordships, even in this matter.
But in ABC versus State of Delhi, the apex court has held the father's name and religion need not be required.
1 second. Go to page 24. Eighth line from,
Yes, sir.
seventh or eighth line from below. All the documents were,
Was his mother's name.
so this is the only issue.
Yes, Your Lordship.
So they will solve it.
I will seek instructions and we will.
You are
do that.
supposed to issue corrected certificate.
Yes,
By correcting the spelling of the name of the mother.
mother.
That's all.
Your Lordship, I've even filed a IA in this matter because the Tahsildar has, we have made several correspondence to the Tahsildar where she has not replied at all. Due to this, I put an IA for impleading the consortium of CLAT consortium and National Law School India University, Your Lordship. So that at least this order which the learned single judge has passed, they can accept that as a EWS certificate until the Tahsildar is ready to give a EWS certificate.
We will ascertain.
And Your Lordship, there's one issue. An amendment of the application is required from Mr. to Miss, Your Lordship.
What is that?
I have filed a memo for a gender identity card issued by the Deputy Commissioner, Your Lordship.
In order to enable learned additional government
That the complainant should carry out the amendment in the petition.
to take instructions 10 over to 2nd July.
I have filed a memo for identification for changing the honor fix from Mr. to Miss, Your Lordship.
On that they will take.
Number 39, Raghunath MD.
I appear for the complainant. Serial number 39 and 39.2.
These matters, my lord, the order is, my lord, for the tenant to deposit the rents in the core. That is partially complied. Not fully complied by them. Lord, they were required to deposit, my lord, 15,50,750. What they have now deposited, my lord, that is what they informed the court, is 14,07,950. Balance that is to be deposited by them, my lord, is 1,42,800.
My lord, I invite your lordship's kind attention to the objections filed by me. Kindly turn to annexure R3 at page 50 in CCC 1184 of 2023. 1184 of 2023, may kindly be referred. Page 50, my lord.
Page
50, annexure R3. This Akbar Trust had filed the suit for ejectment and for other reliefs. Here your lordship will find Shakti Enterprises is the partnership firm. I am appearing for this Shakti Enterprises and the present accused persons are the partners in this Shakti Enterprises. The other respondents, my lord, they are the tenants under me. This Shakti Enterprises had taken the premises on long-term lease of 30 years, wherein Shakti Enterprises had got constructed the building and with the permission of the landlord, the premises were let out to tenants. So therefore, my lord, as on that date, my lord, these responding numbers 2 to 7 were by tenants. Now, my lord, at the time of filing the suit, my lord, this Akbar Trust had filed an application before the trial court seeking a direction to my tenants to deposit the rent in the court. That application was rejected by the trial court. Against that, my lord, a writ petition was filed before this honorable court, and this honorable court had allowed the writ petition. Whereupon this honorable court directed my tenants to deposit the future rent in the court. Then, my lord, during this interim period, certain amount was paid to me. Now, my lord, this defendant numbers 4 and 6, your lordship will find at page 51. 4 and 6, they filed 2 separate applications at page 51, my lord. They are my tenants. They filed 2 applications in the very same suit, seeking directions to me to deposit the rent, whatever I have received from them during the interim period. Now, my lord, this order is allowed. Now, your lordship may kindly turn to the complaint in 1184/2023. That application, your lordship will find it at page 53. In 1183, my lord, page 53, annexure B. And the application, your lordship will find at page 55. This is in respect of the defendant number 6, my lord. He had sought a direction. This defendant number 6 had sought a direction to deposit 12,85,200. Similarly, my lord,
Appeal is also there.
my lord, then, my lord, subsequently, my lord, the suit itself has been disposed, wherein the trial court has passed an order, passed the judgment. Your lordship will find the judgment, operative portion of the judgment. I have produced the certified, produced a copy of the judgment also. The lordship will find it at page 79, my lord. Page 79. Annexure R7. In my objections, my lord. Page 79, R7. The operative portion of the judgment, your lordship will find it at page 134. Even whatever the amount is in deposit in the trial court, I am also entitled to claim it. That is the finding of the learned judge while disposing the suit.
So
Now
what is your claim now?
Now what happened, my lord, is we are the landlords, my lord. We filed a suit for eviction. We filed an application saying he must deposit the rents. At the first instance, my lord, it got rejected. Matter came before the High Court, my lord. Direction was please deposit the rents. In the meantime, my lord, he has collected the rents. So therefore, what those defendants who had paid the rents to him, my lord, they filed an application saying that we were supposed to deposit the rents, but he has collected it. Therefore, instead of us depositing, he must be directed to deposit. That application was allowed. My lords will get the order at page number 103 in the contempt petition 626. So therefore, there is a direction that he must deposit those rents. My lord, he challenges that before this honorable court in a writ petition unsuccessfully. My lord, the order of the trial court, my lord, directing deposit is upheld. He goes to the Supreme Court, my lord. Supreme Court also rejects it. So therefore, now, my lord, the order as it stands today is, my lord, he must deposit the amounts which he has received. Those amounts, my lord, work out to 15,50,000. In partial compliance, my lord, he has deposited 14,07,000. He has to only deposit the balance amount. I don't know why he is feeling shy, my lord, to deposit balance amount. He has deposited 14 lakhs. That is what he says. He has to deposit, my lord, 1,42,000 out of 15 lakhs.
It is an incorrect submission, my lord. I am permitted to take your lordship through the order itself. Kindly turn to Annexure D. In this order, my lord, the amount claimed by the complainant in 1184 is 12,85,200. In the other application, in the other complaint, my lord, the amount claimed was rupees 1,22,750. Totally, it comes to 14,07,950. This amount I have deposited, my lord. This amount has already been deposited in the civil court. Apart from that, your lordship may kindly consider these 3 complaints are filed. Lordship may kindly appreciate, so far as the first complaint is concerned, she has no locus standi to file this complaint, my lord, because she is not the person aggrieved so far as this order at Annexure D is concerned. So far as the second complaint is concerned, my lord, there, my lord, your lordship will find in the plaint, one Mustafa was the owner, was the proprietor of the firm. Your lordship will find it at page 51, my lord. So far as the fourth defendant is concerned, one Syed Mustafa was the proprietor, page 51. Now, this complaint is not filed by this Mustafa. The second complaint is filed by one Mr. Mohammed Shani, claiming himself to be the proprietor. Now, this Mustafa is substituted by this Shani before this honorable court, because in all the earlier proceedings, my lord, it was Mustafa who was the proprietor. Now, he himself has been substituted. Therefore, both those complaints cannot be maintained. Even otherwise, your lordship may kindly consider, after the long lapse of 4 years, these complaints are filed. It is pertaining to the civil dispute. It is an executable order. It is not the order of the learned single judge of this honorable court, my lord. The civil court has passed the judgment saying that I too has claimed the amount in deposit before the trial court. I had to file the memo of calculation. That is the final judgment, my lord.
Not matching. 1184. Where is this?
I may be permitted to take your
So-
lordship.
Where is the direction? What direction you are complying?
It is at page 93, my lord, in CCC 1184 of 2023. the learned civil judge asked me to deposit the rental amount of which I have received. Accordingly, I have deposited. Whatever the amount I have received, my lord, I have deposited. Even that is the amount claimed by them, my lord. If your lordship could kindly turn to their application, that itself shows that this is the amount they have claimed. That amount I have deposited.
Lord,
My
May I
learned
please,
friend can't make a submission that I am shying away to make the deposit. As a matter of fact, my lord, I have deposited 14,07,950. This is the amount claimed. In the first case, it is 12,85,200. In the other case, it is 1,22,750. Irrespective of all these technicalities, my lord, because the complaint is filed after the long lapse of 4 years, my lord. Under section 20, it is 1 year, my lord. And there is a substitution of the proprietor. A stranger has come before this honorable court, claiming himself to be the complainant. Only with you to see that the order of the learned civil judge is complied, my lord, I had deposited the money before him. Now I had to make a claim before the learned civil judge, seeking refund of the very same amount as per the final judgment passed by the learned judge, my lord, while disposing the suits. And even a misrepresentation was made before this honorable court, my lord. The civil judge passed an order. I have filed a writ petition before this honorable court, wherein the period granted by the learned civil judge was extended by 6 months. Now, before this honorable court, the very same order is the order passed by the learned single judge itself is taken as the order non-complied. It is not the original order. It is the order passed under supervisory jurisdiction.
my lord permits me, I'll make. Lord, may kindly come to page 91.
My lord, executable order, my lord.
My lord takes, my lord,
Whatever, if they have any. It will amount to opening the Pandora box, my lord.
May I submit, please? Lord, in 1184 of 23, Lord takes page 59, please. my lord.
You have to first show that where is the direction.
yes, my lord. My lord, he is appearing in the first matter. Lord, I am appearing in
Second matter.
CCC 626.
But order is common.
Yes, my lord, orders.
So where is the direction?
My lord, direction is, first my lords may kindly take, my lord, page number 103. In my lord, CCC, please take CCC 626, my lord. CCC 626 of 2022. Because other two matters, my learned friend is appearing through video conference. Lord, I appear in CCC 626 of 2022.
So in the order which are brought under contempt,
Yes, my lord.
where is the direction?
Yes, my lord. That's what I'm pointing out, my lord. My lord takes CCC 626 of 2022. Lord, please take page number 101, my lord. Page number 101. My lords will get the two amounts, my lord. Page number 101. 14,28,000 is one amount. 1,22,750. Lord, in this, my lord, the final order is, please see page number 103. Lord, defendant number 1, who is the accused here, is directed to deposit the rents within 2 months from the date. Lord, this order was challenged before this court in a writ petition. Now, please take page number, my lord, 120. The order of the trial court was confirmed. Period, my lord, for depositing it, since only 2 months was given, my lord, it was extended by 6 months. Page number 120. Lord, what order I just now showed to my lords at page number 103, that was what was challenged, my lord, before this court. In WP number 43934 of 2019, starting at page number 104, filed by the accused. The order of the trial court, my lord, is confirmed, page number 120. And my lord, period for deposit, my lord, is extended by 6 months. My lords will get at page number 121.
It is not the point. Where is the direction?
Lord, direction is, please see, my lord. The petition stands disposed of permitting the petitioner to deposit the rents received from the first and second respondents for the period from the date so and so, within a period of 6 months. Well, this 6 months is extended because under the earlier order which I pointed to my lords, period was only 2 months. That order was, my lord, challenged. That order is not upset by this honorable court in the writ jurisdiction.
Permitting the petitioner.
Yes, permitting the petitioner to deposit it within 6 months because that order is upheld. Now, within 6 months, my lord, it is not deposited.
Petitioner is deposited.
Now, he has deposited partially. Partially. So, my lord, balance is
out of the rent received.
Yes, my lord, yes. Partially he has deposited, my lord, balance amount he has to deposit.
Whatever the amount I have received, my lord, that I have deposited. In terms of this order of the learned civil judge.
So which direction, Mr. Counsel, we can enforce in contempt jurisdiction?
My lord, it is this direction, my lord. Please see, my lord, page number 119, para 16.
That is not the direction.
Yes, my lord. My lord, the order of the trial court is confirmed, which directs him to deposit the amount. Now, my lord, at page number 120, he is permitted to deposit it within a further period of 6 months. Because, my lord, the 2 months fixed by the trial court has expired.
So further 6 months is expired?
6 months has expired, my lord. Since 6 months has expired and within that period he has not deposited, my lord, the direction given by the honorable learned single judge, my lord, is not complied.
So page 120, no direction which can be subject contempt. So
Lord, direction is, my lord, that he may be permitted to deposit within a further period of 6 months.
Permitted, it's permitted. How can we say if we are not willing
Because
to...
the order of the trial court, my lord, directs him to deposit. That is challenged. That order is confirmed, which is why I was drawing my lord's attention to page 119. That order is confirmed. Now, why the word the learned single judge has probably used saying that he is permitted to deposit within a further period of 6 months is, my lord, because the 2 months, my lord, order fixed under the order, my lord, has expired. So, therefore, they permitted him to deposit within a further period of 6 months. So, essentially, the direction of the trial court, which my lords will get at page number 103, is affirmed. Page number 103, if my lord takes a look, my lord, page number 103. IA dated 4/8/2018, IA number 3 are hereby allowed. Defendant number 1 is directed to deposit the rents collected by defendants 6 and 4 within 2 months from the date of this order.
So against this, there is no contempt.
Against this only there is a contempt, my lord. Therefore,
which one?
Therefore, my lord, that order is challenged by him by filing the writ petition.
Against this order, any contempt is filed?
Yes, no, my lord. That is an order of the trial court, against which, my lord, that was challenged before this court in a writ petition. Writ petition, my lord, that order is upheld.
How many petitions are they connected? Three.
Three.
Let us have the thought.
Very well.
Prima facie, there is no direction which can be brought.
No, I'll be able to demonstrate, my lord. Because, my lord, he challenges that order. This court, my lord, affirms the order, which means, my lord, the direction subsists. He is only given, my lord, further time to deposit. So therefore, he is permitted to deposit within a further period of, my lord, 6 months.
Next Wednesday.
Very well, my lord. Fifth. Very well. Grateful.
Obliged.
Number 40. Kumari,
My lords, I appeal for complaint in this case, my lords.
Lordship appearing.
The matter pertains to issuance of degree certificate, my lords. Writ of mandamus issued by the Annexure A order, my lords. Operative portion is at page number 17, wherein the university was directed to issue executive MBA degree certificate to the petitioner, and the respondent to UGC was directed to grant no objection certificate, my lords, to issue the degree certificate. The complainant has made a representation on 24/1/2023, my lords, by the Annexure B, which has been duly received by the university on 29/1/2024, my lords, by the Annexure D. And the certificates are yet to be issued, my lords.
That I appear for case number 1, my lord.
Lordship.
Against the impugned order, my lord, writ appeal has been preferred. And writ appeal 188 of 2024, my lord, that is said to be listed before this court.
Appeal is preferred.
Yes, my lord. WA 188 of
Let it be
2020.
together.
Yes, my lord.
To be listed with.
Lordship appearing on behalf of respondent number 2, Lordship, UGC. Today we have filed Wakalat, Lordship. Hence, the council seeks time to file statement of objection, Lordship.
19th of July.
Much obliged.
Your Lordship, a mention in serial number 38, if it may be taken next week. As the urgency is NLSIU is requesting the EWS circuit on 28 June for admissions. Your Lordship?
Go on.
Next week, Your Lordship.
Which one? Next 41.
Next week, 41.
Gone. That is gone. Which is gone never comes. And it will come back on 2nd July.
Your Lordship, the urgency is NLSIU is the top one national law school in India. So an admission cancelled from that is difficult.
All of a
to get
sudden
in.
you are reminding of urgency.
Your Lordship?
It's already adjourned to 2nd July. Now urgency is reminded.
Your Lordship, if a small consideration can be made over here for next week.
You are there? What is the matter? That certificate.
I have got reservation NLSIU under the EWS quota. So without the EWS certificate, there is no admission to NLSIU.
You want to take some admission?
I have given a provisional admission into National Law School, India University, Bangalore.
When do you?
The 6th or 7th, Your Lordship.
Next week. That is 7.
Because he submitted that to 28 July is the date when they have to submit it. For 15th of June.
Then others. 15.
Obliged, Your Lordship.
Fourteen June.
41.
Number 41 already adjourned. You want to argue? No.
I'm appearing for the petitioner.
I know.
Number 41.
Yes, madam. Yes, madam. Court is 41. Rate appeal, rate petition.
With petition.
Compliance of office objects. Yes.
My lord, I am appearing for the petitioner. The petitioner has also applied for memo of appearance. He is also an advocate.
Yes.
And he can assist me in this matter because regarding technicalities of the subject, he is more knowledgeable. So I request the honorable court to grant permission to the
No,
petitioner.
no, that permission can be granted. We are nobody to grant permission. If you want to argue a part in person, 6 certificate under which rule? Form C. Form C.
No, forms, he's an advocate by profession now.
Other than he become, he may enter his appearance.
It is exempted actually.
He can't be permitted to argue on your behalf. You can be permitted to argue on his behalf, since you're advocate.
Can assist her in technicality of the.
You sit down and assist. Yes.
My lord, this petition has been filed challenging the consent for establishment issued by Karnataka State Pollution Board. Respondent number 1. Respondent number 1, without verifying the misrepresentations, that is the glaring misrepresentation with respect to the port capacity. The Karwar port, which has proposed to develop second stage development at Baitkol village, which extends to the Karwar beach, affecting the Karwar beach. And this CFE consent for establishment has been issued for that, wherein the application of the KSPCB, they have mentioned it as 4.5 million tons per annum. But all the supporting documents like the DPR, the detailed project report, the pre-feasibility report, which is attached as annexures here, annexure D, my lord, at page number 163, mentions it as 20 million ton per annum. But the application has been given for 4 million ton per annum, and the consent has been obtained. Even the EC, the environment clearance, has been obtained on that basis. So this is a glaring misrepresentation which can have an adverse effect on the environment. The capacity of port.
Reply your file.
Impugned order is issued by respondent number 1, my lord, that is the Karnataka State Pollution Board. Yes.
My lords, I appear for the Karnataka State Pollution Control Board. A copy of the petition has not been served upon us, my lords. A copy of the petition.
It has been served. It has been served.
Not been served.
The notice, the daily orders mention it. Notice has been taken by them.
Notice has been taken, my lord. A copy of the petition
has been served.
not been served.
It was up. They appeared, Mr.
Guru
Joshi. Mr.
yes.
Joshi appeared.
He instructed me saying it's not served.
It was served.
We don't have a copy.
Okay, I'll give a copy of it. But it has been served to all. All the respondents have been served and notice has been taken. My lord,
We don't know.
there was a direction for them. My lords, there was a direction for the
You
KSPCB.
can serve another copy.
No, yes, ma'am.
Another copy you can.
I don't have right now, my
No,
lord.
you can get it Xerox.
Okay, my lord.
And if you want to address the court, you are advocate? Advocate?
Yes, my
He's an advocate.
Come in dress and address.
Thank you.
So
Can I submit?
then without copy, how?
Yeah, copy has been served, my lord.
No, so.
Knowledge.
Anyway, I'll serve it again. But all the respondents have been served. Can you please give a date, my lord, this matter?
Whenever you serve, week thereafter.
1 week.
1 week, within 1 week, you serve the court. Then 2 weeks, 1st of July.
Obliged, ma'am.
Hope you are served or not? Now tell truth. Hope you are served to your. Hope you are served.
No, no, my lordship. No, no, your lordship.
Mr. Joshi, it was, he had appeared.
No, Mr. Joshi was the one that instructed to make this submission saying he hasn't been served a copy.
Anyway.
What is your name?
My name is Rishabh, Your Lordship. Rishabh.
Number 42. The Bharat Kumar S.
Appearing for the state, my lord.
Yes, madam.
My lord, in this matter, actually the cost title says non-filing of report by the Principal Secretary Revenue Department by virtue of the order 25/7/2023. However, my lord, my submission is that pursuant to the 25/7/23 order, the government has filed a memo dated 25/9/2023, bringing before your lordship as to what has transpired pursuant to the impugned orders, that is annexure H and H1, and the representation of the petitioner herein. The memo is dated, my lord, 25/9/2023. And thereupon, my lord, there are various orders that have been passed by this honorable court. In the memo, my lord, we have stated in a report that there is certain fraudulent orders passed by the then AC, changing the mutation of some land in survey number 6 and 7, which was B Karab, government land, into the name of one GM Shivanna. Sorry. KS Giridhar is the name in whose name it's been mutated, and Shivanna was the then AC, my lord. Public interest litigation is filed against the orders of the AC as to how the government land, which was B Karab, was given to a private person. And therefore, my lord, we have filed a memo dated 25/9 stating as to what all has happened. First, pursuant to the 29/5 memo, there has been other orders which has asked for certain
But
clarification.
they want some mutation entry.
Mutation entry
Do we,
was,
may I submit minutes? The counsel for the petitioner filed a memo for retirement. My lord, this honorable court accept, they rejected the request, and my lord, I have been requested to, my lord, assist this honorable court as amicus. But the orders which are challenged in the public interest litigation is, my lords, Annexure F, page 109, is an order passed under the provisions of Karnataka Land Reforms Act, holding that the purchase made by the vendor of the fifth respondent.
109.
Page 109, my lord, is the order. It was passed for resumption of the land under the Land Reforms Act. The translation is at 111.
One second.
This is an order passed under the provisions of Karnataka Land Reforms Act, but holding that the purchase made by the vendor of the fifth respondent is void because, my lord, she was not an agriculturist, my lord, to hold the agriculture land. This order was passed in the year 1997. But the fifth respondent, who claims to be the subsequent purchaser, let's say, has filed an appeal before this third respondent under section 136(2) of the Land Revenue Act, contending that fraudulently the revenue entries are mutated in the name of the government. Therefore, he is an aggrieved party. But the third respondent assistant commissioner entertained the appeal filed under section 136(2) against an order passed under the provisions of Karnataka Land Reforms Act, and holds that the order passed by his predecessor is wrong. But he had no authority to entertain the appeal at all at the first instance, because against an order passed under the provisions of Land Reforms Act, an appeal lies before the Karnataka Appellate Tribunal. But he usurped the powers of the Karnataka Appellate Tribunal, and he passed an order in the year 2021 in setting aside the order of 1997.
But against this page 111 order also appeal will be live.
Against this order, my lord, the appeal lies before the Karnataka Appellate Tribunal.
Correct.
This here, my lord, the power is exercised by the assistant commissioner, who is not the authority under the, my lord, the provisions of the Land Reforms Act.
That contention you can raise in the appeal before the tribunal.
The
That's
entire
it is
allegation in the public interest
It is a public interest litigation, my lord.
is that the AC has usurped the power of the appellate tribunal and passed the impugned orders, my lord, at annexure H and H1, page 200 and 204. Is the impugned order of the AC usurping the powers of the tribunal?
That the very same order has been set aside by the single judge of this Honorable High Court in writ petition 7406 of 2021, my lord. So the order dated 9/3/97, passed by the second respondent assistant commissioner in the year 97, is no more available. It has been set aside. I have produced the copy of that order in page number 90 of my statement of objections. Page number 90.
Where is the impugned order? Order which is sought to be set aside in this petition.
Annex
20
H, minutes, page 202. 202 minutes.
202, not 111.
202 minutes.
202 and 204 minutes.
202.
Annexure H and H1, my lord.
The provisions quoted, my lord, in
But why PIL?
It
Because
has
it's
been
a
filed,
current-
Malad, contending that Malad, the land was vested, Malad, pursuant to 1997 order. Therefore, the government, Malad, is not protecting the.
You can exhaust the hierarchy of appeal in the, under the revenue law. Why PIL?
The petitioner who filed a petition as a public interest litigation, he would not be an aggrieved party, Malad, before the authorities. Malad, he cannot, Malad, file an appeal because he is not an aggrieved party, Malad. 1997 order, by virtue of 1997 order.
So what public interest it is not?
That, by the order of 1997, the land vested in the government. From 1997 till 2021, the name of the government was reflected in the revenue records. But all of a sudden, in 2021, by virtue of the impugned order, the name of the fifth respondent has been ordered to be entered, holding that the order of 1997 is void. He has exercised the power under section 136(2) of the Karnataka Land Revenue Act, under which the order passed under Land Reforms Act would not have been set aside. He had no authority to set aside an order passed under Land Reforms Act. That order could be challenged only in an appeal before the under section 118 before of the Land Reforms Act before the Karnataka Appellate Tribunal.
However, my lord, what has happened?
So, madam, this order at 202 will be appealable?
Please, my lord.
Under which provision? Under the revenue law. Let us see the language of the section.
My lord,
It
now,
is appealable under section
now the
118.
Karnataka Land Reforms Act has been amended, my lord. Now this provision for forfeiting the lands is not available. It has been deleted. In view of that amendment, many writ petitions have been filed and all have been allowed, my lord. Likewise, my vendor's sister, daughter-in-law filed the writ petition challenging the very same order, claiming that she is the owner of the property. That writ petition has been allowed by this honorable court.
It will consider, let us see if there is appellate provision of appeal or whatever.
Now it is not available.
But, section 118 minutes
Oh,
of
yes.
the Karnataka Land
It is
Reforms
bound
Act.
to be there, yes. 180.
Since that provision has been deleted, this writ petition has been filed and this honorable court has allowed the writ petition on 1/9/2022. And the order dated 3/3/97, impugned order, has been set aside.
Section 2 of section 118. Every order passed by the deputy commissioner may read this.
These are orders passed under 136(2), my lord. The appeal of the AC goes to the DC, but the entire issue is that he has usurped the tribunal powers of the tribunal.
So revision would lie or appeal would lie?
Let appeal minutes.
That appeal has been filed by the government and it is pending before the deputy commissioner, my lord. This very same order has been challenged by the government. It is pending. I have produced the certified copy of the order sheet before the deputy commissioner.
Any question?
Against an order at page 109.
Revision to the deputy commissioner, that is pending, my lord.
Let's.
Yes, yes. Page number 95. 96.
So land,
Let
my
the
lord, what has happened is,
It has been
passed an
converted
interim
from-
order. Passed an interim order, my lord, directing the authorities to, my lord, keep the land as, my lord, as
as
is.
government land.
We'll consider today time is over.
Now, the revision petition is pending before the Deputy Commissioner Bank. In RP 384 of 22 and 385 of 23. Two revision petitions are pending. Challenging the very same order.
Take on 24th.
Pardon?
24th will take.
Please, yes, ma'am.
How many meters are left? Several.
My lord, in the cause list, it shows that we have not complied with the order 25/7/2023. We have complied by filing a memo, my lord. That I would like to bring to your lordship's notice in this matter, my lord. So we have complied by filing the memo dated 25/9, subsequent to that order 25/7.
Serial number 46.
All will be distributed. Yes.
49, if I may request for the matter to be listed tomorrow.
Why?
It's a great urgency. It's been a year since we filed the matter. There's an application for stay pending.
Application for?
For stay matters, our application for a stay.
Not tomorrow.
On
Date will
the
be.
last date of hearing, senior counsel had requested for early disposal. In view of the
Tomorrow listing will also not be possible. Day after is what? Monday.
That 46.
Serial number 52.
Will distribute it.
Item number 58.
As early as possible, dates will be.
That 46 also date may can be given on Monday.
All dates will.
Item number 58, there is some urgency, my request is please of 50 minutes. My appointment, I was appointed as president LCH. From past 3 years, I was working. The nurse single judge minutes has passed my appointment order. Some urgency, my lord. Now, admission, my lords, and other procedures of new colleges are going on. President has a role, my lords.
24th.
Monday,
Serial
my lord.
number 59, my lord. Yes, 14%. Please consider we are completed all office objections. And please take all the order taken preliminary hearing.
Time.
This is
you
urgency
want-
for me.
Whatever time. Party.
Serial number 59.
Time, do you need time?
No, you are already completed all the objections.
Then it will be listed for hearing at appropriate.
Preliminary.
58, my request on Monday, my lord. 58, Monday,
Monday, not.
Tuesday, there's some urgency, my lord.
24 is Monday.